ECA matter, insurance company, entire amount is deposited.
Why it is not posted? We should ask the registry.
I've asked them and they said that.
No, you should ask the registry why it is not posted.
I've asked them.
What did they say?
People said that from particular date it has been said that within 24 hours it has to be posted. Otherwise, you have to move the.
What is that? What does that matter? Which year is that?
26.
26. Why? Who said? Ask them to. Who is that? Call them. Why did they say so? Not required. All matters that are numbered, they have to be numbered within 24 hours. They have to come before the court. Then they will come.
True. That's what they said. But what they said is that they fixed some particular.
No, nothing is fixed. Nothing is fixed. All fresh matters. I've directed them to post the matters. I will again give the instruction. I will not take not even one memo in the fresh matters. As a matter of, all of us are going to adopt that because there is an SOP. All matters will be listed within 24 hours. If they are not being listed, please bring it to the notice of the court. The same will be looked into by the registrar judicial. This matter, what is happening to that matter, find out. Why it is not listed. Please don't give any fresh matter. Yes, other than that.
My lords.
Yes. First of all, you have to tell me which year is the writ petition. Have you complied with all the office objections? Same. Take all the matters, fresh matters, why they are not listed. Find out from the registry. Yes, if anybody has the same problem, give it to the court officer. He will find out. Yes, other than that, please.
Your lordship.
Which year is that? No, what the difficulty I'm finding here is interim orders that are granted in 16, 17, 18, 19, 20, nothing. There is no time for that court to take up. 26 matter today interim order, tomorrow vacate. There should be some priority. No, every matter will have urgency, but there is some priority should be there. It's because the manner in which these matters are entertained, no more matters are taken up. That's not right, isn't it? People who against whom a stay is granted about 5 years back, that should have the priority. Yes, that's not yes.
Lordship. Lordship's pending matter, your lordship.
That case, your lordship, 25 to 2025, that the insurance company has filed and deposited the money, and they have only paid an withdrawal of amount.
Yes, please.
Your lordship, pending matter, your lordship.
Huh? Is it a case of death or take that. Yes.
Your lordship, pending matter.
Tomorrow.
My lords.
We will fix.
Your lordship, pending matter, your lordship. Parties are ready for compromise, your lordship.
Yes.
My lords.
Matter, your lordship. The responsible valid property suit has been stayed, right? Tomorrow.
No. Yes.
A date will fix, your lordship.
No. Yes.
The pending matter, your lordship. There is the urgency there.
We will see. We will see all pending matters every day with this kind of mentioning will not happen. I will not entertain these mentions. Let the matters come. Give time to the court. Every matter will be taken up. Not that every time memo is moved, whoever moves a memo, if that matter only has to be heard, what is the issue in that? It's called the list.
Your lordship.
Take all the
Lords,
memos.
kindly. Lords, kindly, my lords.
One submission.
My lord, on submission,
My lord.
my lord, it has to be referred to mediation, my lord. Already we have exchanged the memo of calculation.
The court officer. Do I have to tell you again?
One
Go to the court officer.
My lord,
My
on
lords,
submission, my
kindly,
lord.
my lords.
position notice has been issued, my lords, in Sarfaesi Act.
If you file, it will come.
I filed it yesterday, my lord. Kindly have it.
24 hours, I said, it will come. I will not take it up any matter out of the turn. Please call the list.
My lord.
My
My
lords.
lords, kindly, my lords.
Yes.
Page wise judgment, list number 1.
Your lordship, see list 2, serial number 8, your lordship. Pray for which
Have you
time?
heard what he said? You should follow what is happening in the court. He said list 1. Yes.
Page 1, serial number 1 to 5. Page 2, serial number 6 to 11. Page 3, 12 to 40. Page 4, serial number 21 to 31. page 5, 32 to 41,
33 minutes.
33.
So my mistake, by mistake, I did not bring the file, though it is kept on the table.
You moved the memo, Mr. Counsel.
No, the reason is I forgotten to bring the file, it's a fresh matter.
Why the matter should be listed? And why you have given the memo, why you have forgot? List this matter after 4 weeks.
No, one request, minutes.
We will not entertain any request.
Then I will arrange to bring the file, not.
Yes, please do that. Let it be. Yes.
Page number 6, till number 42 to 47.
44 Lordship.
40?
4.
Yes.
I am for petitioner.
Respondent has filed the maintenance, my lord.
What do you want?
He has not paid any maintenance in lower court, ma'am.
Paid?
Lordship, dual maintenance Lordship, I used to seek the week's time Lordship.
3 weeks paid, kindly kept on Monday, my lord.
No, don't call any of the orders matters, no mentionings in orders matters.
The week's time Lordship, council for
We will
petitioner,
see. What happened?
council for petitioner out of station Lordship.
Admission, page wise
Next week Lordship, please.
We'll see when it is coming up for orders, for what it is coming. Yes, orders don't call.
Page number 11, till number 63 to 64.
My lord,
Page number 12,
60
70.
65 and 66, my lord, 65 and 66 are connected to one more company appeal, 105074. There are 3 appeals, 2 appeals have been listed.
Page 9.
Serial number 8, Your Lordship, sir.
Yes.
I pray for petitioner. I pray for week's time, Your Lordship, sir.
Matter which is not in the list for that memo. Matter which is in the list for that adjournment.
Please.
My lord,
2 weeks
65
time,
and 66, my lord.
I will not extend intermodal. Why
Seek
to?
instruction, to seek instruction from the parties, Your Lordship, sir.
We'll see what
We are not
instructions are
told that
required.
matter,
No,
Your Lordship,
I
that
will
has
not
been listed
adjourn any
today.
matter in the list.
My lord, serial number 9. My lord,
My lord,
Serial
serial number
list number 2,
64.
serial number 9, my lords. My lords, I am for the respondent number 5. My lords, may request on day up to tomorrow, my lords.
Have you informed the other side?
Please, already inform.
Yes.
Serial
This is
number 9,
matter
my lords.
65 and
tomorrow.
66,
My lord,
my lord.
serial number 64.
65 and 66
Yes. call
are
the-
connected to one more company appeal, 105074, my lord.
Matter number 30 Saukar, if you would be.
Please.
Please.
With respect to Sarfaesi matter, my lords.
No, you said yesterday that there is no.
No schemes prevailing.
They say that there is no scheme prevailing.
And even, my lords, if there,
I produce the document, my lord. Let him, if he, there is him, let him file an affidavit. I produce the document which they have issued it. I filed along with my memo, my lord.
for the same reason, my lords, we have not received any OTS application. We have received only compromise approval letter, my lords, which needs, the main branch needs to approve that same. It is not an OTS application.
If your remedy is available to you, please avail that. Then the present petition is filed, seeking the following prayer.
May I pass on the, my lord, that application which I have produced?
Record that, take that. The facts of the case are, the petitioner has availed the loan of rupees 45 lakhs from the respondent number 2 bank on the security of the immobile property. When the petitioner have failed to pay the amount, the account was declared as NPA and the proceedings were initiated under the Sarfaesi Act. A notice under section 13(2) was issued on 1/6/2022. And it is a case that because of the court, the petitioner could not make the payment. Then the respondent bank has moved the senior civil judge and CJM couple under section 14 of the Act, and an order was passed on 3/9/2024. And by order dated and appointed a court commissioner to take position and hand over the same to the respondents. Then the court commissioner has issued a notice dated 30/5/2025, calling upon the petitioner to hand over the vacant position within 7 days from the date of the notice. It is a case that the petitioner requested the respondent to give some time and OTS facilities so as to repay the loan due to loss in the business. It is a grievance of the petitioner that the respondent have not considered the request of the petitioner. The reasonable request of the petitioner for the one-time settlement, hence he has come before this court. However, the prayer that is sought is to quash the order that is passed under section 14 of the Sarfaesi Act. When counsel for the petitioner submits that he is ready for a one-time settlement. When the matter came up on the last occasion, this court has directed the counsel for the respondent to get specific instructions to whether a scheme is available for considering the case of the petitioner and a one-time settlement. It is the instruction of the learned counsel appearing for the respondent bank that there is no scheme in place and the case of the petitioner. They will not be able to consider the case of the petitioner for one-time settlement. Learned counsel appearing for the
It has been received by them and I paid 5,10,000 rupees.
counsel for the respondent. The petitioner has placed a letter dated 8/1/2026.
Next page, I paid 5,10,000 rupees.
Now, to whom it is addressed? Format of compromise offered to be obtained from the borrower.
Yes, madam, that is the bank itself not has given. In the down below, they have received the endorsement. There is a.
That a letter is given by the bank and they have in that regard, they have paid an amount of rupees 5 lakhs.
5,10,000.
5,10,000. The petition has come before the court questioning the proceedings initiated under section 14 of the Sarfaesi Act. The writ petition as filed before this court is not maintainable for the reason that the petitioner has an effective alternative remedy of approaching the DRT. Apart from that, this court do not see any legal grounds. As far as the one-time settlement is concerned, in the light of the settled law, there cannot be any direction to the bank to grant a one-time settlement to the petitioner, to the borrower. Then if the bank is coming forward with a compromise with the petitioner, that is between the bank and the respondent and their liberty to proceed so. However, the present writ petition as filed cannot be entertained. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies available to him. Yes, number 2.
Please.
Preliminary hearing matter, seal number 2. G. N. Raichur.
My lord, I am for the petitioner, my lord.
Yes.
My lord, serial number
And there are
2,
other connected
8,
matters.
9, 11, 15, 16, 19, 20, 21, 22. In all these cases, similar question is involved that whether the claim petition filed beyond the period of 6 months as prescribed under section 166 subclause the motor vehicle is maintainable or not. That rejection of the intra-order application filed under 711.
The other day, I've seen one judgment of a single judge of this court saying that is ordered. So now, why should this court take a different view from that view? That is
Because I got an answer for that, my lord.
Yes.
That was a question which I in the previous last occasion has been raised.
Yes.
My lord, the judgment of this honorable court, what my lord has referred, rendered by Honorable Justice Suraj Gondiraj, wherein that was pertaining to prior to the amendment. That was extent took place prior to amendment.
So, give that order. I don't think so. That's not prior to the amendment.
Yes, my lord.
That judgment last time it was there in the file. Justice Suraj Gondiraj's order in these matters. Please pass on the copy.
Quite pass the copy.
What it was represented is, it is after the amendment.
No, my lord, that was prior to the amendment.
Will you read para 4?
The submission of Muhammad Abdul Qayyum, learned counsel for the petitioner insurance company, is that in view of subsection 3 of section 160 of the Motor Vehicle Act 1988, no claim petition shall be entertained unless it is made within 6 months of the occurrence of the accident. In that to the matter, the substance.
What is the amendment? What is prior to amendment?
My lord, in 1988, the limitation period has been introduced. that claim petition is required to be filed within a period of 6 months. In 1994, there's an amendment that whatever the limitation which have been introduced has been again taken away in 1988 Act. Again, same has been introduced in the 2019.
Correct. No, when you look at paragraph 4 of this order, they were referring to that only.
No, my lord, this is they deferred 167 subclause 3, but because the amendment came into force with effect 1/4/2022.
Discussed by the learned judge?
Date of action prior to that one,
No, was it discussed by the learned judge?
that was date of action had not been taken into consideration.
So ultimately, the judge has gone with the, considering 166(3), where there is an embargo to file a claim petition after 6 months. So that is what we have to present.
Yes,
Let's read it.
The correctness of the certain, because apart from the Karnataka High Court, there are others, the High Court has passed a judgment, my lord, which has been challenged before Supreme Court. Which has been challenged before the Supreme Court, wherein Honorable Supreme Court has granted the stay, my lord. I'll pass on the copy.
This is when Krishna Munari, it's long back, 4/5/2023.
Still, it is pending, my lord. Moreover, the constitutional validity of section 166 subclause 3 has been challenged by some of the claimants in the Bhagirathi case. This is also pending for consideration. And as per the tentative date, my lord, at 10th of this month, the matters is going to be listed.
What has happened to the matters that are filed between 23 to 26?
All the matters of the BBs are pending. Now the matter is pending for consideration on the 10th of this month, my lord, before the apex court. Because last again it has been heard and it has been adjourned. So again, now the next date of hearing before the apex court is 10th of February of this month. And in the on the previous occasion, there was a specific order by the apex court that not to precipitate the matter. Direction will be given to all the high courts and the tribunal that not to precipitate the matter, not to reject the application filed for condition of delay until disposal of those cases, my lord. By order dated, my lord, 25/1/2026, there was an order stating that
No petition shall be dismissed on the ground of delay.
it is made clear that during the pendency of these petitions, the tribunal or the high court shall not dismiss the claims petitions on the ground of such petitions as barred by limitation, as prescribed under subsection 3 of section 1866 subclause 3 of the Motor Vehicles Act 1988.
Done with these matters now?
My lord, it is tentative on the 10th of this month, my lord.
Yes. It is submitted that with regard to the validity of 163(3), 166(3) is pending before the Honorable Apex Court, and it is going to be listed on to be heard on 10th of February. List these matters on 23rd of February. What are they? How many are they? 1, 2?
My lord, serial number 2, 8, 9, 11, 15, 16, 19, 20, 21 and 22.
15, 16?
20, 21, 22.
Even
19 also. 21, 22.
All these matters on that day.
And in the meantime, my lord.
Tag on all these matters. Yes.
What has happened is, if there is no order of state, then the matter would be disposed of, allowing the dismissal.
So in the meantime, in the meantime,
there shall be a direction to the trial court, not to, there shall be stay of all further proceedings.
Please.
the notice is to come after, my lord. Notice.
The respondent.
My lord, sir, one more submission. Serial number 8 and 9.
8 is?
8 and 9.
Yes, they was given the list.
He is claiming that these are prior to the action, he don't want to continue this matter, 8 and 9. 8 and 9.
They can be disposed of?
No. That is another connected matter that we will distribute along with this connected matter. We will withdraw this case.
8 and 9.
Will withdraw 8 and 9.
Yes, ma'am.
Next judgment.
Unless these matters?
Along with this case.
On, why should we have it on that day, 10th?
Same. The connected case is already state granted. That may be listed along with this.
The list along with so and so on 10th, 8, 9, along with that list.
Yes, please.
Much obliged.
Yes, next.
Seal number 3.
Appear for the petitioner, my lords.
Rishadwad, Srinande Pachapura.
Yes.
This writ petition, my lord, is by the defendant.
When is the interim order granted in this?
Interim order is granted, my lord, on 27/6/2025.
Filed vacating, my lords, on 18/11. Only for the reason that, my lords, now sugarcane crop, my lords, has been grown up, my lords. It's getting dry, my lords. Since from 72, my lords.
I'll submit on the merits, my lord,
yes,
if my lords permit me, my lord.
Come to the impugned order.
Please. My lord, this writ petition is calling in question the reversal by an appellate court exercising jurisdiction under Order 43 Rule 1, my lord, wherein the trial court had rejected the application filed under Order 39 Rule 1 and 2 by the respondent plaintiffs.
First, let's see the appellate court's order.
Appellate court's order, yes, my lord. It starts from page 45, my lords. It is in
40?
45. I'm sorry, it is in Kannada, my lords. If my learned friend, my lord, I'll translate for my lords, my lord. If my learned friend disputes it, my lord, then I'll file translation. Otherwise, no. I'll submit the gist of the order.
No, it's not that. When I am dealing with an order, I should.
Yes, I should have filed, my lord, a translated copy, my lord. It did not cross my mind.
Taken steps when you're insisting for it. When you're insisting the matter to be heard, you should have seen that it is in Kannada and you should have filed a translated copy of it.
It was equally my duty, my lords. I should have. I'm the petitioner, my lord.
Why I have said is like.
Please.
You
No,
are
no,
not
understood, my lord,
insisting,
but
you
still.
have an interim order in your favor.
Yes.
I do
should have
take
done
that
it,
responsibility, my lord.
Let's say, let him, let's.
Please file it. When will you file? Day after, Friday.
One day's accommodation, my lord, I'll file it.
Today's, Wednesday, Friday. At
Please.
the request, this is a matter on Friday. 4.
Please. There's an interim order, my lord, that may.
Interim order only
Yes.
granted is this.
Please.
Yes, next.
Seal number 4.
This is
Umme
pertaining to
Salma?
parole matter.
Parole matter.
Yes.
Umme Salma, seal number 4.
Do the file.
Yes.
Please.
Take that order. The present writ petition is filed. Seeking the following prayer. It is the case that the petitioner's brother is lodged in Central Prison, Dharwad, and is undergoing the sentence of life imprisonment with fine for the offences under Section 366 of IPC and Section 6 of the Protection of Children from Sexual Offences Act 2012 and Section 32E of the Scheduled Castes and Scheduled Tribes Act. No, in this case, the parole is rejected according to them.
Yes, ma'am. Exactly.
Where is then it is, how will this judgment apply?
That is the guidelines issued, ma'am.
No,
Please.
it is a case where the parties have come to the court questioning seeking a parole.
Yes.
Now, when the parole is rejected, there is option is this, on what ground it is rejected? Please come to that. Page number.
Yes. I don't have.
Case number. Will hang on.
What kind of pleadings? No documents, nothing. Such a pathetic state. What is the averment? What is the document? Some cut and paste from some other petition.
Yes.
The convict prisoner filed a writ petition before this court seeking grant of parole for a period of 90 days, and the same has been rejected.
ಆಕ್ಟಿವ್ ಮೋಡಲ್ ಬಂದಿಲ್ಲ ಅವರು, ಆಕ್ಟಿವ್ ಮೋಡಲ್ ಬಂದಿಲ್ಲ ಪಾರ್ಟಿಸಿಪೇಷನ್. ಮೆಮೋದಲ್ಲಿ ಬಂದಾರೆ, ಮೆಮೋದಲ್ಲಿ ಇದ್ದಾರೆ. ಪ್ಯಾಸಿವಲ್ ಇದ್ದಾರೆ, ಪ್ಯಾಸಿವಲ್.
Have you seen this? Papers are served on you?
Not, my lords, paper served, but I don't have paper, my lords, filed.
Why they don't serve the papers on you? This matter is coming up on several occasions.
Yes.
It's coming up from from 10th month. I request court requires some help from the respondent. Now, you pass on an order saying that it is covered. This case, Justice Suraj Govindra has dismissed the writ petition on 22nd of August 2025, stating that writ petition stands dismissed. Liberty is reserved to the petitioner to approach this court once again after serving at least 5 years. This order is passed on 22nd August.
Yes.
You need to have all the files. Please go through the files.
Yes. Kindly have done tomorrow.
It is stated that the respondents denied the parole to the petitioner's brother without any cogent reason, whereas the conduct of the convict in jail is satisfactory. It is stated that the petitioner's brother has undergone the actual custody of 5 years, 5 months and 8 days as per the imprisonment certificate. It is stated that the convict prisoner has filed a writ petition before this court seeking grant of parole for a period of 90 days, and same has been rejected. And now, earlier the writ petition is filed by the mother, now it is filed by the brother. And now he is seeking a parole of 90 days for getting the treatment of his mother, as she is seriously suffering from many ailments and no one is at home who can get treated the convict's mother. They have no other effective alternative remedy, hence they have come up before this court. This writ petition is filed. This writ petition has come up before the court on 19/11/2025. And it is adjourned on 24/11/2025, 8/12/2025. Today, when the matter is called, there is no representation on behalf of the petitioner. The writ petitions are being filed seeking parole before this court, which is contrary to section 191 of the prison rules. This court in WP 109758 of 2025 has passed a detailed order.
Para 4, my lords.
that whenever the application is filed by the convict, the jail authorities strictly, in accordance with Rule 191 of the Karnataka prison rules, shall consider the case and shall pass an order. He shall, if they have not received any report from the concerned magistrate or the stationer's officer within 15 days, it shall be deemed that there is no adverse, that there are no adverse remarks against the same, and the Inspector General of Prisons shall proceed in accordance with Rule 191 of the Karnataka prison rules. Earlier writ petition, that is dated 22nd August, that is WP number 103386 of 2025, dated 22nd August 2025. It is observed that there is no particular emergency which has arisen for such release of the detainee who has only served 3 years, 11 months, 19 days as on 28/3/2025. And a liberty was reserved to approach the court once again after serving at least 5 years. In the considered opinion of this court, in the light of Rule 191 of the prison rules, the High Court cannot, High Court generally, in the general course, shall not pass an order of parole unless it is brought to the notice of the, unless it is an exceptional case. Yes, and even in that also, when the prison authorities are supposed to act as per section 191, if they are not acting, there shall be a direction to them to act in accordance with law. For granting a parole, all the necessary documents, the conduct of the prisoner and other antecedents will be placed before the jail authorities, which will facilitate them to consider it in accordance with rules and pass an order. In that view of the matter, this court do not find any reasons to pass any order in this writ petition. Accordingly, the writ petition is disposed of, giving liberty to avail the alternative remedies. So take this, give it to him. Yes, next.
Please. Seal number 5.
Let's,
Subhendu Act
for
Award.
petitioners, this is with regards to setting up of telecommunication tower.
Yes, what are your instructions?
So I'm for the third respondent.
Yes.
Respondent number 3 has filed their objections on the ground of radiation that is emanating from the tower. I could lay my hands on as many as 29 judgments of various high courts.
Yes, that is now ruled out.
That is the only ground, Other than that, there is no.
But officials have rejected that application based on that.
Only
That
on
I
this.
produced.
No, ultimately what
Yes,
happens
yes,
is
that's-
everybody, nobody wants radiation,
Yes.
everybody wants to use a cell phone. So where from the signals will come?
Yes, I know that various, even Supreme Court also said like.
That's a consistent view.
In most of those cases, petition number 1 itself is a petitioner in those high courts as well.
Also that 222 rule, amendment rules, that's also not required. Only that they have to inform the commissioner. I know that.
What is it, what are the judgments you're relying on?
Sir.
Any of this court?
Some are of Bombay High Court and Delhi High Court. The latest one being the PI filed before Bombay High Court.
In spite of that, Your Lordship, that rule itself is very clear.
Which rule?
That telegraph rules amendment 2022, which I don't have.
I have. It's not annex, rule number 15. May I pass?
Not rule number 15, it is a rule 10B. It's very clear. Other than 10B,
You
not
find
15.
the rules here.
What?
You find it.
No, I've not filed. It's a separate. I've mentioned it in my grounds of grounds.
But it is a 15B, but it is actually 10B, it is information to the commissioner. That's only.
May I take notes to the
These rules are called establishment, operation and maintenance of overground telecommunication network in public property.
please. Previously, there was in Telegraph Act as well as Telegraph Right of Way Rules. Those were repealed, and now it is Telecommunication Act as well as Telecommunication Right of Way Rules 2024, which is placed before.
In this Read that 4,
Let's please.
15-4.
15.4. In the case of establishment, operation and maintenance of mobile tower or pole over such property, the facility provider shall prior to commencement of such establishment submit information in writing in the form provided for this purpose on the portal to the concerned public entity along with the details of the building or structure where the establishment of
He means referring to some panchayat or.
please municipal corporations plots. Establishment of the mobile tower or pole in is proposed and a copy of the certification by the structural engineer authorized by the public entity attesting to the structural safety of the building or structure where the mobile tower or pole is proposed.
The present petition is filed, seeking the following prayer.
10B, your lordship, that also it's very clear. 10B, 10B, rule 10B.
Let's see.
Sir, idhar tha.
15 alla, 10B. Hey, idhar tha.
Maybe seen.
10B.
Yes.
To the relevant public entity to identify the public property on which such temporary overground network may be established.
No, that is applicable where the establishment of the tower is required in a public property, Millards.
Temporary overground telecommunication.
In public property. This is a private property, that is rule 15, Millards.
Yes.
Please.
The present petition, so and so it's like the prayer.
But anyhow, my contention that rejected, that application is rejected, that justified that order.
Yes. The facts of the case are, the petitioner number 1 is a telecom infrastructure company and petitioner number 2 is the owner of the land. The petitioner number 1 company is carrying on the business inter alia of operating mobile telephone services, the way of providing network in several states in India, including the state of Karnataka. The petitioner company is managing towers of many private telecom operators and maintaining their assets such as DAC fibers, right of way, dark fiber, duct space for the purpose of grant on lease, public rent and sale basis. The licensees telecommunication services under Section 4 of the Indian Telegraph Act 1885 on mutually agreed terms and conditions. It is submitted that the petition number 1 has identified the land belonging to petitioner number 2 for setting up of a tower. In this backdrop, the petition number 1 sought to install a tower in the property of the second petitioner. The second petitioner has executed a lease deed in favor of petition number 1 company, permitting petition number 1 company to install and operate mobile tower in the property for a period of 10 years, starting from 1/8/2025 to 31/7/2025. Thereafter, they obtained a stability report from the export agency who have accepted to go ahead for installation of the tower in the open space of the property to the extent of 20/20. And the petition number 1 has invested huge sums of money in the procurement of material in order to commission and installation of the tower and devices worth more than 40 lakhs. Thereafter, he has submitted an application on the online portal of the third respondent. And to the surprise of the petitioner, the respondents have issued the impugned communication rejecting the request of the petitioner. What did they say?
On radiation issue, it has been rejected on 6/12/2025.
It is stated that installation of a tower
Based on the complaint made by that locality, within radius of 50 meters, already 3 existence towers are there. That is the objection.
It is stated that within the radius of 3 kilometers, another 3 towers are there as it emanates radiation. And basing on the complaint given by the locality
Residents.
people, the they have issued the impugned communication rejecting the request of the petitioner for erection of the tower. Next, tower. The agreed thereby the petition is before this court. Learned counsel appearing for the petitioner submits that the respondents have no such authority to reject the case of the petitioner for installation of a tower on the ground that it will eliminate radiation. He had drawn the attention of the court to the
That's a telecommunication right of way rules, my lords. Please.
Establishment, operation, what are these called?
That's telecommunication right of way rules 2024, my lords.
22, 24.
24, sir.
Where do you get this, the name of the rules?
Lords, it's mentioned.
Indian Telegraph right of way rules.
Huh?
Indian Telegraph right of rules, Your Worship.
Short title, as placed before this court, the telecommunication within brackets right of way rules 2024.
Please.
And he had relied on rule number 15.4.
Please.
Which reads thus, please extract this. 15.4, which is marked. Land council submits that as per the said rule, no permission. The respondent, no such ground is available to the respondents to reject the case of the petitioner. It is submitted that as per the said rule, when they have given an application along with the structural stability report, the respondents have to consider the same. Land counsel appearing, the land counsel for the petitioner had relied on the orders passed by the High Court of Bombay in case of Jagruk Nagarik Sangatana and others versus State of Maharashtra and others. He relied on paragraph number?
Let's from paragraph number 13 onwards, Mulats. 13, Mulats, 15, 18, 24, 25 Mulats. Take Mulats to page paragraph number 13 Mulats.
Paragraph number 14. Take from paragraph number 14, 15, 16, 17, 18.
Please.
And 19 also. Basing on, and he was also relied on, and the judgment of the Bombay High Court in case of Indus Towers Limited and another versus Gram Panchayat Tanang Taluk and another arising out of writ petition number 15903 of 2024. He relied on paragraph number
from 42 Mulats.
These are all extractions.
Please, Mulats, all these are the same on the same ground of emission, Mulats.
Paragraph number 50. Then, yes.
Paragraph number 6, Mulats.
Then the other judgment is, in a similar line, he has relied on the judgment of the Delhi High Court in WPC 11831 of 2021 and CMAPPL 36584 of 2021, where in arising between Indus Towers Limited was North Delhi Municipal Corporation. Relying on all these, whenever I say paragraph, it should be extracted. Relying on these judgments, then counsel submits that the respondents cannot reject the case of the petitioner. Next para, land counsel appearing for third respondent submits that considering the complaints that are received from the local people and considering the fact that already there are another three towers
already existent
installed within the 3 kilometers.
15 meters.
Huh?
50 meters.
Earlier also same.
50 meters.
50, within 50 meters radius, already 3 towers are
So
installed.
para second of the statement I have stated.
Rejected the request of the petitioner in the light of the petitioner. Hence, there is no irregularity with the said order. Next para, having heard the counsel's finding the said there is a material on record. The installation of these towers is governed by the
Telecommunication infrastructure.
telecommunication right of way rules 2024.
Please.
Chapter 2 deals with establishment, operation and maintenance of underground telecommunication network in public property. Then chapter 5 deals with establishment, operation and maintenance of telecommunication network in property other than public property.
Please.
And section 15.4 as it is extracted in the preceding paragraphs makes it clear that the party who wants to install a tower shall submit information in writing in the form provided for this purpose on the portal to the concerned public entity along with details of the building or structure where the establishment of the mobile tower or pole is proposed, and a copy of certificate by the structural engineer authorized by the public entity attesting to the structural safety of the building or structure where the mobile tower or pole is proposed to be established. This makes it very clear that the limited power that has to be exercised by the third respondent is to look at whether or not. Apart from that, the Act does not confer any other right on the third respondent municipality. In this case, it is not the case with the respondent that the structure is that there is no structural stability there is no stability to the said structure, and as prescribed under section 15.4, no such the certificate is placed before the court. In that view of the matter, the third respondents have no right to interfere with the installation of the tower. Accordingly, this court is passing the following order. The proceedings stated.
Annexure B, my lords.
1 minute. The order passed the.
So I have produced that R1 order has been produced, the endorsement R1, your lordship, that is online application rejected, only one line that in annexure
So
B.
and so, order dated so and so. The communication dated, what is the date of the communication?
Let's
6/12/2025.
lots. 6/12/25.
2025 in annexure number,
R1.
annexure B.
B, my lords, B.
Annexure
Please.
B is set aside. And the respondent shall consider the application of the petitioner in accordance with rule 10.4 of the
15.4, my lords.
15.4 of the
Telecommunication right of
rules within a period of.
So 2 months, your lordship. 1 month.
My lords, actually, even that is not required. Once it is quashed, my lords,
Even
we
that
can
also
set up.
not,
my lords.
I know that officials, please.
Keep it pending again, you have to come back.
Yeah.
So, actually, what has happened, my lords, under the
Period of 1 week from the date of receipt of the copy
let's
of
even
the-
respondent number 5 may be directed, my lords, police authorities, in case if there is any
All
situation.
that vaccination things. we
Lords,
will
what
not
has
do.
happened there, locals will come once.
Locals.
Why should you though presume that they will not give you permission? Yes,
Grateful, my lords.
yes. Next.
Number 6.
Lords, serial number 6.1 is the main file.
Huh?
Serial number 6.1 is the main file.
Take 6.1.
Lords, the petitioner being aggrieved by the order passed by the Honorable Senior Civil Judge Bailhongal. We have filed I number 4 under order 8 rule 9 read with section 151 CPC, and petitioner seeking permission to file additional written statement to the main petition was
No,
dismissed.
I don't want all that. Please come to the order straight away. You are the plaintiff or the defendant.
Plaintiff.
What
Petitioner.
happened, what happened to your petition?
Dismissed by the trial court
Uh,
to seeking permission to additional written statement to the main petition.
Come to the impugned order, where is it? Page number?
Page number, my lords. Page number 62.
60?
62, my lords. Annex E.
Please read that order, a very short order.
This is an application filed by the respondent number 1 and 2 under order 8, rule 9, read with 151 CPC, seeking leave of this tribunal to file additional written statement or objection to the main petition. It is aware in the affidavit filed by the respondent number 1 on his own behalf and behalf of the respondent number 2 that during the course of cross-examination of PW1, certain material facts have come into the light which were not incorporated in the earlier written statement. It is contained that unless the respondents are permitted to place said fact on the record by way of additional written statement, they will suffer irreparable loss and injuries where no prejudice will be caused to the petitioner. Accordingly, the response prayed allowing the application. Per contra, learned counsel for the petitioner filed a detailed objection opposing the application containing that the present application misconceived, belated, and filed only with intention to protect the proceeding. It is urged that respondents, though they entered the appearance on the 28/7/2000, failed to file their objection within a stipulated time and filed their written statement objection belatedly only on 15/12/2024 after obtaining a leave of this tribunal. Thereafter, on 31/7/2022, they filed another application by recalling the cross-examination which was allowed on the despite of the several arguments and warning the respondents have now come of the present application seeking to file an objection. It is further contained that respondents they have not shown any newly discovered facts and changes comes in the challenge, omission, or work due their own negligence. The application is therefore the running but an abuse of process intent to delay or proceeding and defeat the object of the speedy disposal of the claim petition. Hence, prayed for this dismissal of the petition.
Where is the application?
Page number 58, my lords. The time the respondent number 1. May I read, my lords?
When did you file your written statement? No.
On dated, my lords.
You want to file additional written statement after PW1's cross and again recall is done.
My lordship, there is submission in this case. At the time of the cross of examination was going on, PW1 stated that at the time of the accident, the motorcycle was having an insurance of the said vehicle. And that we are not aware about those things. That's facts at the time of the investigation or cross examination. They only came to know that there was a motorcycle no Yuma Ittu, and she's admitted that at the time of the cross examination. And that insurance company, it is not on the record. So in this case, my lordship, my contention is that this petitioner along with this.
No, is it your submission that in the cross examination, if new facts are elicited from a witness,
yes,
that would be a ground to file additional written statement?
Yes, my lords.
Because to add a new issue.
New issues, because proper issue is not been framed by the trial court. So this, my lords, I am relying the judgment by the Honorable Supreme Court on India, and my lordship has clearly stated that there is a ground, lordship, there is new ground of defense in case of the Olympic Interstate versus Mullah. The Honorable Supreme Court held that even by filing an amendment or additional written statement,
Give the judgment.
this will provide, madam. By afternoon, will provide.
This is matter after 3 days, next week. You have to be ready with the judgments when you are arguing. You can't write it on a paper and read the judgment. Yes. Next week.
Next.
Yes,
Seal number 7. SC Chaklab. Chetan Munwali, AG.
The petitioner in this case, writ of mandamus seeking direction to the respondent number 3 to consider my representation. In my representation, I requested the respondent number 3 authority to release my EMD and FSD amount. Already the work has been completed in the year 2019. Till this day, they have not refunded my EMD amount and FSD amount.
Lords, we'll consider it and pass up.
It is in accordance with law.
Yes.
If he is entitled, he is entitled.
Yes,
You should tell them.
Yes,
please.
one request. Let it be a court order.
Yes, sir. The present petition is filed.
All 3 petitions and a different representation.
That's why we'll pass independently.
Independently, please.
The present petition is filed, seeking the following prayer. It is a case that on 24/7/2017, the respondents have issued a tender notification. And the work has been issued to the petitioner. Petitioner has completed the work and the respondents have issued a satisfactory certificate to the respondent. It is a case of the petitioner that in spite of, even after completing the work,
Respond number 3.
the respondents have not released the earnest money deposit of an amount of 2,98,500 and FST deducted in running bills to the tune of rupees 14,96,503. He has made several representations to the respondents, but the respondents have failed to consider the same, which made the petitioner to come before this court. It is submitted that there shall be a direction to the respondent to consider his representation. Then counsel appearing for which respondent? Third respondent.
2 and 3, my lords.
2 and 3 submits that he would get instructions in this regard. Next part. When the petitioner has given representations to the respondents that they have to return the EMD amount and the other amounts, the respondents are duty bound to consider the same in accordance with law and tell the petitioner whether he is entitled, whether he is entitled for the same or not. Then the petitioner would avail the appropriate remedy available to him, but it is not appropriate on the part of the petitioner to keep quiet without taking any action on the representation. The latest being on 29/9/2025.
Lordship.
29/9/2025 is the latest.
Yes, it is the latest
on
representation.
29/9/2025. These circumstances, this court is of view that no instructions are required to be obtained by the counsel appearing for the respondent number 2 and 3. In that view of the matter, this court is passing the following order. The respondent number 2 and 3 shall consider the representation dated 29/9/2025 given by the in accordance with law as expeditiously as possible, but not later than
12 weeks.
No. 2019 ಅಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
but not later than 8 weeks.
Please.
4 weeks is
4 weeks.
Please. My lords, let it be 8 weeks, my lords. Sometimes division office is in Koppal and head office is in Bangalore.
Ultimately, you have waited for this much time.
At least.
Matter, it is 4 weeks.
Please.
8 weeks.
8 weeks.
Give the next one.
Same representation date has to change.
All amount must be different.
Amount.
That's what I'll tell him the amount.
Please.
Then WP number 1088.
I will mention in my representations.
So in this 16/5/2020 is the same order. 16/5/2020 is the tender notification. Then the work is allotted to the petitioner and petitioner has completed the work. Then he gave a representation on 1/10/2025 to release of the earnest money deposit and further security deposit at 18% to a tune of rupees 6,22,385. That's it. 6,22,000 in the other one. No, that's not the, that is
11
not
lakh.
correct what is stated in the facts.
ಅಲ್ಲ, in the
Earnest
annexure
money
A, I have
deposit
mentioned all the
and
things.
FST deducting in running bills to the tune of rupees 21,50,000. They have released, the respondent authorities have released 75% of the EMD and FST amount of rupees 8,91,330.
70 ಅಲ್ಲ, 50%.
But remaining EMD and FST, the respondents are assured, but they have not. This is at paragraph number 9 for the correct figures. Yes, same order like in the other one. Next matter. Please come. WP number 108890. In this 22/8/2017 is the tender notification. He has completed the work and the petitioner has sought for release of the payment of earnest money deposit and further security deposit with interest as 18%, which comes to 31,93,968.
Please.
And the representation is in this?
Same 29,925. 29,925. Annexure A.
That's all differs, just have a check it. Accordingly disposed of.
Please. God bless.
Ten.
Seal number 10. Seal number 10. Naina Rajendran. Early. Manoj, now.
I am for the respondent, my lord. The petitioner has filed an application to recall PW1's.
For the petition, my lord.
Today she was not able
Yes, Your
to
Lordship.
wait for a day. She says that it should happen by evening, by the time it's said. Yes.
No, my lords, I have an urgency, that's why I'm also under pressure, my lords.
But you have to understand the court's
Yes,
pressure
yes,
also.
my lords, indeed, my lords.
Only one pressure. Yes, where is the order?
Yes, my lords. My lords, the order is annexure D and E, annexure F, my lords. Sorry, annexure G, my lords, the order.
Page number.
Page number 134, my lords.
Who are you, the plaintiff or the defendant?
I'm the plaintiff, my lords. I'm plaintiff number 1, my lords.
Suit for?
This is a suit for partition, my lords. Partition in separate position. The suit was filed in 2008. It was dismissed. There was an RFA which was filed in 2011. The RFA came to be allowed, my lords, and the suit came to be remanded back to the trial court. Now, in the trial court also, the evidence, even though PW1 has already given his evidence, I was coming as PW2, my lords, because I'm adducing additional evidence, my lords. The evidence was marked, the documents were marked, additional documents were marked, my lords. I'm a senior citizen, and when the next day itself, it was kept for cross-examination. I'm a senior citizen, I have certain health issues, so I had to go for an doctor's appointment. So the counsel in the trial court had made a request to be called in the afternoon session, my lords. In spite of that, the cross-examination was taken as nil, my lords, and my entire evidence was discarded.
Please come. Page number
134, my lords.
There is order. Please read. Order. Suit is, remand is when?
2011, the 2014, my lords.
What is this suit
From-
going from 2014 till
That's
now?
what, Your Lordship. She has, for 11 years, she has been kept dormant. In fact, the very evidence of the PW2 have been eschewed. It has been discarded by the learned trial court in the order. There is no question of recalling of the evidence.
2014 to 24, what is happening?
My lords, what has happened is that in the suit for partition, there was only
I'm not asking about the facts. I'm saying after a remand in 2014 till 2026, what's happening?
Yes, my lords, that's what I am explaining, my lords. In 2014, I was not knowing about it. My brother, that is the respondent number 1 in this case, my lord, he was looking after the entire proceedings, my lord, on behalf of myself as well. Now what has happened is he took a loan and he has sold certain properties as well, my lords. And from 2014 till 2026, respondent number 1 and respondent number 2, there was an order specifically by this honorable court not to create any third party interest on the suit scheduled properties till the partition is decided. The respondent number 2 has specifically sold off the properties and created third party interests, my lord. So when I got to know, I had to file additional IAs in order to correct and get the other parties also on record, my lords. That is why it took so much of time, my lords, to collect all the
If Your
documents.
Lordship permits, I'll-
When did he sell the property?
in the year 2014,
2022
itself.
onwards, my lords.
Now,
Then what is happening till 22? Suit, why the suit is not proceeded from 14 to 22? Now by the time only for, what was the kind of remand?
Your Lordship, it was dismissed for non-joinder of certain properties and non-joinder of certain parties. So it was remanded back with the
It has started afresh.
afresh after remand. But in fact, Your Lordship, in the order passed by the learned trial court judge, wherein specifically it states that in the year 2017, Your Lordship, a writ was
Wait a
filed.
minute, let's read that.
Page number 141 of the petition, at para number 10, point number 2.
We'll start from paragraph number 9. Paragraph number 9 will start.
Please, Your Lordship.
In this case,
In this para number 1, para number 9, Your Lordship, in this point number 1, it is regard to defend number 8 has filed IA for recalling. That is the present bank.
we'll read
Please.
this order.
In point number 1, in this case, plaintiff number 6 examined as PW1 by himself and on behalf of other plaintiffs on dated 16/1/2017. Thereafter, further chief examined on 14/3/2022. He was subjected to cross-examination by the counsel for defendant number 1 to 4.
So.
Already PW1 has led the evidence, Your Lordship.
First, the plaintiff's examination
Was on 14/3/2022, Your Lordship. That is plaintiff number 6. He himself has led as PW1.
plaintiff is on 16/1/2017.
Yes, Your Lordship.
Thereafter, further was on 14/3/22.
14/3/2022. And he was subjected to cross-examination by counsel number defendant number 1 to 4 on dated 26/3/2022. The cross-examination by the defendant number 5A, 5B and defendant number 6 taken as nil. On dated 19/8/2024, the counsel for plaintiff number 1 to 5 has filed an application under order under 1 Rule 10(2) of the CPC to implead defendant number 8 in the year 2024, Your Lordship, to implead us. The said application came to be allowed on 7/3/2025 and the defendant number 8 brought on record and on dated 25/3/25 he filed a written statement. Now after 8 months from the date of impleading, the defendant number 8 has filed this application to recall PW1 for cross-examination after filing written statement. My learned predecessor has framed additional issues and posted the case for appearance and further examination of in chief of PW1. From the date of the appearance, the defendant number 8 has not taken any steps to recall the PW1 for cross-examination. Now after 8 months from the date of appearance, he has filed this application. There is no sufficient reasons mentioned in the application to recall PW1 to lead the cross-examination by the defendant number 8. Moreover, on dated 17/7/2000, the counsel 1 Sri RBD for Low Command Society is present and furnished the documents as sought by the plaintiff number 1 to 5. Hence, the oral and documentary evidence produced by both the parties are more and enough for adjudication of the matter. Hence, the question of recalling of PW1 for cross-examination by defendant number 8 does not arise at all. Accordingly, point number answered in the negative. This is for the cross-examination filed by the defendant number 8 for recalling of PW1. Your Lordship. Further, for point number 2, Your Lordship, there is a IA filed by the plaintiffs.
Read them.
Yes. The plaintiffs have filed this suit in the year 2008. When the case posted for arguments, the plaintiff have filed application for amendment, which was allowed. Again, the case posted for arguments on the merits in the year 2023. At that time, the plaintiff number 1 to 5 counsel filed application for
What does
implement.
it mean? Right from the date he has never come. First time.
No, yes, Your Lordship, she has not come.
He has come. What is that you have to understand from this? For amendment which was allowed. The
Yeah,
case
that was
posted for
allowed.
in the, it says,
Yes.
for the first time, the case is posted for arguments on merits in the year 2023.
Yes, Your Lordship. It was posted for argument.
Where is that? Where is the order sheet? Do you have an order sheet of the court?
No,
What is happening?
complete entire order sheet I do not have, Your Lordship.
Read.
Further, Lordship, at the time, the plaintiff number 1 to 5 counsel filed application for implementing on the dated 29/5/2023. A learned predecessor has observed that in this Honorable High Court has clearly given a direction to this court to dispose the matter within 6 months from the date of receipt of order passed in WP number 110657/2017 dated 27/9/2020. Since from the date of passing the order by Honorable High Court, the plaintiffs have filed several interim application under order 1 Rule 10 CPC and wrote letter for extension of the time for disposing the matter. In this case, already the evidence of PW1 is on record and he was subjected to cross-examination. Moreover, the plaintiff number 6, that is the PW1, has adduced his evidence on his behalf and also on behalf of other plaintiffs also. Hence, the question of plaintiff number 1 adducing her evidence independently does not arise at all. On the dated 26/3/2025, an additional issues framed and case posted for further examination of chief of PW1, if any on additional issues. Since the counsel for plaintiff number has filed several applications, one after other, the stage was not utilized by PW1 nor adduced any additional evidence. As per the letter written by my learned predecessor, further Honorable High Court has extended 1 year time for disposal of the suit, which was completed on 28/6/2025. As per the notification of Honorable High Court, I have taken charge of this court in the month of June 2025 and wrote a letter to the Honorable High Court for extension of time to dispose the matter. Again, Honorable High Court has extended another 6 months for disposal of the case, which will be completed in the month of December 2025. By perusing the order sheet and record, it reveals that since from the date of passing order by the Honorable Court, the plaintiff number 1 to 5 counsel has filed several interim applications under order 1 Rule 10, 6 Rule 17, CPC. All the applications are disposed of. Though there was several direction from this honorable court to cooperating in disposing the matter, the plaintiff number 1 to 5 counsel filing the applications one after the other, and they are not cooperating in disposing the matter. In order to avoid the multiplicity of the proceedings, this court has allowed the applications and additional issues were framed and permitted parties to adduce additional evidence. Thereafter, the plaintiff number 1 to 5, without conducting further evidence of PW1, they have adduced the evidence of plaintiff number 1 as PW2 and got marked several documents. As the plaintiff number 1 already adduced his evidence on his behalf and also on behalf of other plaintiffs, again the plaintiff number 1 conducting her evidence independently is not accepted. In spite of direction from this honorable court, the attitude and conduct of the plaintiff number 1 to 5 clearly shows that they are not obeying the order of honorable high court. And since from the date of remand, the plaintiffs have taken very leniently and not obeying the honorable high court and not cooperating this court to comply the order. Hence, there is no sufficient reason made out for the counsel for plaintiff number 1 to 5 to recall PW2 and tender her for cross-examination. As the plaintiff number 6, his evidence on behalf of all plaintiffs, the oral and documented. Already, Your Lordship, the PW1 has led the evidence. Now, after 11 years, she has been kept dormant. Now, to overcome the lacunas in the admissions given by the PW1, she is adducing new evidence, Your Lordship. That's why the learned trial court has held that
Is it correct that that whoever has adduced evidence, he is the one who sold the properties?
No, Your Lordship, he is not the sole. The another brother, Your Lordship, that is respond number 1, the defend number 1.
Respond number 2, my lords.
Respond number 2. It's a colluding suit, Your Lordship.
No, respondent is defendant. You mean
A defendant, Your Lordship.
Defendant, my lords.
Defendant.
Defendant number
He
1 is
the
respond
seller.
number 2,
One
my
of the
lords.
brother is the seller of that property, Your Lordship. He has made.
Oh, no. Who is contesting on behalf of all the plaintiffs?
My lords, a small clarification that I would like to give to this honorable court is that when plaintiff number 6 was adducing his evidence, he was adducing on behalf of all of us, that is plaintiff number 1 to 5 as well. But after he has given his evidence, he colluded with the defendant number 1, that is a respondent number 2, and sold another property without the consent of the plaintiff. This was a suit scheduled property itself, my
Oh, in
lords.
that regard, you have already filed an IA. You brought everything on record.
Yes,
Why
my lords.
should there be another again cross-examination of that person now?
My lords, I'm adducing new evidences, new documents, my lords. Exhibit 43 to 78 that I have produced before.
What is that it is required? If person has sold the property because there is a sale deed before the court.
Yes, my lords, the new sale deed itself I have produced before the court.
Why again you require all this again recalling, again another cross-examination? Why is it required?
My lords, what has happened in this case is that when the plaintiff number 6 and the plaintiff number 1 to 5 have are not going together now because of the actions of the plaintiff number 6 that he colluded with the defendant number 1, my lords, by selling all these properties. And once we have taken the new documents, when we have gathered all the new documents of sale, now the learned counsel appearing over here who is contesting, my lords, he's appearing for one of the purchasers, my lords. We have already filed a case of contempt as well before this honorable court, because as per the order of the honorable high court as well,
Yes.
as per the order of the honorable high court as well, it was a very specific order given that you can develop the property, but you cannot create any third party interest, my lord. But here, after the honorable high court remanded back the matter,
For all those aspects, why do you have to cross-examine him? That's what I'm asking. And why do you want to, this is nothing but delay tactics. Why do you want to? No, as far as the sale of the property is concerned, one, you have already pleaded the subject, but they are on record. For that, you don't have to cross-examine anybody. Sale has taken place on record, number one. So what the evidence that in as of now, no, that evidence can't be disputed in light of the fact that he has sold the property. No, everything is there on record. You can go ahead with the order. This is a suit of 2014. High Court so far has granted 3 times extension. And again, you are filing one, and all your applications are entered by the court. Yes, please come.
My lords,
Read whether
if I may.
the past.
my lords, a small suggestion, my lords. My senior is on VC, my lords, if he can be unmuted.
Yes. Yes.
Yes. The clarity on the matter is the fact that there were 2 loans which were taken by both the brothers.
Sir, please re-log in.
Yes, just a minute.
Agreed with the order. Passed in I number 49 and 50 in OS number 37 of 2008. Dated 29/11/2025. Plaintiff number 2, or what is your, your
to
arraigned
5.
as plaintiff number?
1 to 5.
1 to 5, my lords.
Plaintiff number 1 to 5 or before this.
My lords.
The facts of the case. The plaintiffs have filed a suit. 1 to 5, 1 to 6 have filed a suit for partition. And plaintiff number 6 is leading the evidence, filing, is taking care of the entire case on behalf of the other plaintiffs. That suit came to be dismissed on, when was the order?
Am I audible?
That suit came to be dismissed on 1/6/2011. Agreed with the same, the petitioners have preferred an appeal, that is RFA number 3126 of 2011, dated
My lords.
1/7/2000. Yes,
Yes, my lords. I seek apologies for the internet connection over here. The contention, what my lords is seeking, is the fact that there were 2 prior loans that were taken by both the brothers. One was informed to us, wherein we have assented to it, and later on a property was sold with respect to clearing of the loan. The second part is a loan which was hidden from us. During the course of the trial, the parties, the ladies got to know there was a hidden loan taken by both the brothers. With respect to this, that is why there was a falling off between the brother and the sisters. If this fact is not brought before the honorable court, then the brothers and the sisters will have been deceived. The sisters will have been deceived in this matter. The crux of the matter as to why PW2 was brought forward was the matter of fact that there was a loan which was not known to the sisters, which were taken by the brother and the sister, and one of the property in the suit was auctioned off during the course of the suit. The respondent number, if I'm not wrong, respondent number 10 and 12, the subsequent purchases, and the auctioneer, the bank, the Lokmanya, is also present before this honorable court. They can affirm to this fact that during the course of the trial in 22 and 23, the property was auctioned off, but the loan was taken in 93 and another loan was taken in 2006. The 93 loan was known to the sisters and 2006 loan was not known to the sisters. And the parties that were made, the Lokmanya Society, the subsequent purchaser, the Marfani, and the subsequent purchasers to the fact of 2015 RFA order, who purchased the property in violation of the court's order, all of this fact is not brought before the honorable court.
yes.
So with respect to these, my lords, the fact remains that the brothers have deceived the sisters and have made sure that a property is sold in abeyance, and now no property remains in the suit. One of the brothers has sold 4 properties. Both the brothers together took a loan and 1 property was sold. All the 5 properties are sold off now.
All the purchases of the property are before the court.
Yes, my
Yes, my
lords.
lords.
Yes.
All the purchasers are before the court, but now the question remains whether they have purchased the property in violation of the court's order in RFA.
If
Date will show, the dates will show when was an interim order, when was the sale deed.
My lords, I agree. But at the same time, the second loan was not informed by the PW1 before the honorable court. This is a very important factor. If the
Let us see
second
your
loan,
IA. Let us see your IA. Where did you say all these facts? Come to the IA.
my
IA in support
amendment
of
may be
this.
seen, my lords.
Yes. Yes. Where is the IA?
126 page.
126, my lords.
126 annexure D.
Annexure D, my lords.
Yes. No, what is the reason for recall? Where is it stated? Where is it stated?
Nothing is
Nothing
stated.
is stated.
No reasons are given.
No reasons.
Yes, please write.
Lord, and if we see the impugned order, now the court has given a right to lead chief examination by PW1. They have a right to cross-examine PW1. also.
PW1, it may.
The suit came to be dismissed. Then against that RFA number 3126 of 2011 is filed, which came to be dismissed on 1/7/2011. They preferred an appeal before this court, that is RFA number 3126 of 2011.
Yes.
And by order dated 18/2/2014, the matter was, the judgment and decree was set aside and the matter was remanded for trial. It is now the plaintiffs 1 to 5 have filed an application to recall PW6.
PW2, my lords, plaintiff number 1, my lords.
To recall
PW2, plaintiff number 1,
PW2.
who is appearing as PW2.
recall the plaintiff number 1 for further cross-examination. And also another application is filed and defendant number 8 also filed another one.
I number 48 is filed by defendant number 8, my
I
lords.
number 48 is filed to recall PW1 and a common order is passed by the court. The court, while dismissing rejecting I number 48 and 50, filed by defendant number 8. And plaintiff,
As far as I number 48 is concerned, my lord, it was filed by me.
you are
That-
not questioned it.
Because, my lord, it is kept for the further chief examination of PW1. I was recalling him to cross-examine him. So I will get a right to cross-examine PW1.
No. Now, how can, they need not question I number 48.
48,
filed
they have
by
not, they have
two.
not challenged.
They have not challenged it.
Only
My lords, I have not filed I number 48. I have filed 49 and 50.
49 and 50.
Look at the prayer. Look at the prayer. Only they have questioned I number
49 and 50, my lords.
49 and 50, my lords.
Lord, 50,
48 to 50. What is 50?
50 is permission to file further examination in chief by PW2.
IA number 50 is filed to file further examination in chief.
The second loan documents, my lords.
All these IAs are dismissed by way of a common order. While considering the applications and while rejecting the applications, the court has observed that the suit is filed in the year and when the suit was filed and from how long it is pending. It is observed that on 29/5/2023, the learned predecessor has observed that the High Court has clearly given a direction to the court to dispose of the matter within 6 months. That is in WP number 110657 of 2017, dated 27/9/2021. After that, several applications are filed under Order 1 Rule 10 by the plaintiffs and the same were allowed. The plaintiff number 6 has adduced his evidence on his behalf and also on behalf of other plaintiffs. Hence, question of plaintiff number 1 adducing their evidence independently does not arise. It is observed that on 26/3/2025, an additional issue framed and case is posted for further examination chief of PW1, if any, on additional issues. The counsel for plaintiff number 1 to 5 has filed several applications, one after the other. That stage was utilized by PW1, nor reduced any additional evidence. Then the High Court has extended the time for disposal of, that is 1 year, on 28/6/2025. Then again, time was extended for another 6 months for the disposal of the case, and the same will be completed in the month of December 2025. The court observes that the order sheet reveals that since from the date of passing of the order by the High Court, the plaintiffs 1 to 5 have filed several interim applications under Order 1 Rule 10 and 6 Rule 17. All the applications are disposed of. The court observed that the plaintiff 1 and 5 are not cooperating for the disposal of the matter. The plaintiffs number 1 and 5, without conducting further evidence of PW1, they have adduced the evidence of plaintiff number 1 as PW2 and got marked several documents. As the plaintiff number 1 already adduced his evidence on his behalf and also on behalf of the other plaintiffs, this is wrong, I think. It is plaintiff number 6.
Plaintiff number 6 is the PW1, Your Lord.
The plaintiff number 6 has already adduced his evidence on his behalf. No, it says plaintiff number 1.
Yes, that's wrong.
Plaintiff number 6 has already adduced his evidence on his behalf and also on behalf of other plaintiffs. Again, the plaintiff number 1 conducting her evidence independently is not accepted. The court felt that there is no sufficient reason made out by the counsel for the plaintiff number 1 and 5 to recall PW2 and tender her for cross-examination. Accordingly, the court felt that there are no grounds and these applications are filed only to drag on the proceedings and accordingly rejected the same. When counsel appearing for the petitioner, that is the plaintiff number 1 to 5, submits that the plaintiff number 6 was conducting the case and and in fact, contrary to the orders of the court, he has alienated the property. And to bring all that on record, they have filed several applications and there is no intention on the part of the plaintiff to drag on the matter. Unless the plaintiff number 1 adduces evidence as PW2, and place all the facts on record. And unless you want to cross-examine PW6.
PW2, yes, my lords. I'm ready to keep her present, my lords. That's the only
We
contention.
are about
I'm-
to cross-examine, Your Lordship.
They have to cross-examine.
Keep her present tomorrow itself. Or today afternoon at 3 o'clock, if my lord permits.
My lord, we want to cross-examine PW1 because subsequent purchasers, my lord. And
PW2 because we are adducing addition.
the trial court has passed an order for examination of chief on the additional issues, my lord. So if they lead their examination, further examination, then that right should be given to all the defendants to cross-examine PW1.
It is submitted that unless and until the unless and until an evidence, unless and until an opportunity is granted to lead further evidence of PW1.
PW2.
I'm PW2, my lords.
That is that is plaintiff number 1.
Plaintiff number 1.
Yes,
Unless
plaintiff
and
number
until an
1.
opportunity is granted to plaintiff number 1 to lead further evidence, they would not be able to face all the facts and the sales that are and the regular sales that are entered into by the 6th
Plaintiff, my lords.
it is submitted that the reason they have filed a petition stating that the PW2, who is plaintiff number 1, was not feeling well as on that day, and hence they sought for time.
My lords, I did not seek for time. Only I was not present in the morning session.
They were not present in the morning session as PW2, that is plaintiff number 1, was not keeping well, and the court ought to have accommodated the plaintiff, accommodated PW, the plaintiff number 1, and ought not to have closed his evidence. Then counsels appearing for your defendant number.
For defendant number, Your Lordship.
Purchasers, my lords.
Purchasers, Your Lordship.
Defend number 9, my lords.
Defendant number.
Defendant number, Your Lordship.
Defendant number 7, Lords. Respond number 10.
And counsel appearing for defendant 7.
8. I am for
defendant number 8 and
9 to 32.
14,
Defendant number 7 and 8 are the family members.
No, my lord.
No, my lords.
The bank
society
and the
with which
subsequent
they had
purchaser.
availed loan.
You also purchaser.
I'm also purchasing.
I'm also, we
The
are also
defendant
purchasers.
number 7, 8 and defendant number
14 and so defend number 11 and defend number 15. Thereafter, your lordship,
He
from
collectively represents 9 to
20
32, my
to
lords.
28, your lordship.
8 is the society which had given loan.
let him say what are the whom
Please.
you are representing.
Because I'm representing for defend number 11, your lordship, and thereafter,
Name is printed in the cause list.
yes, your
Yes, my
lordship.
Know from this.
Yes,
What is your name?
Manoj Jain Bikkan, your lordship.
The learned counsel appearing for R 14, 20, 21, 22, 24, 25, 27, 28, 30 to 37.
Yes, sir.
You are for R 11.
I am for R11.
For R11 oblique D8.
Defendant number
Defend number 8,
Number
my
eight.
lords.
And
Yes, my lords.
counsel appearing for R10 oblique D7.
7.
Yes, my lords.
7, submit that. They are all the subsequent purchases. If an opportunity is given to the PW1, the property, the plaintiffs, the court has rightly considered and dismiss the application that was filed on behalf of plaintiffs 1 to 5. It is submitted that if, shall I record that an opportunity is given to them for cross-examining, for further evidence, you shall be given an opportunity to cross-examine them. It is submitted that
They are a limited
Yes, you have to
opportunity.
if their request
Time
is
bound maybe.
considered, if their request is considered.
I'll keep a
and if
present
this
tomorrow.
grants an opportunity for further, to lead further examination of PW1, PW1, the
PW2, my lords.
The further examination of plaintiff number 1 as PW2. An opportunity may be given to all the purchasers, to all the purchasers who were impleaded.
Lord, I am the society and society also needs to be given. I am defendant number 8. They had availed loan from
Lokmanya
me.
Bank.
All the purchasers and also the society from whom they have availed the loan shall be given an opportunity to
Yes.
cross-examine PW2.
Yes,
And all the, and they will, and this then there may be a timeline to
Yes, ma'am.
complete the examination and cross-examination.
Yes, my lords.
This court, having heard the counsels on either side, peruse the material on record. It is so unfortunate that a case which is remanded in the year 2008
2014, my lords, it was remanded.
Demanded.
is pending before the court till 2026. It appears that the court has accommodated the parties and has given them their sweet time to prosecute the matter. This court is conscious of the fact that the matter is pending from 2014. When for 2014, just because there is a direction from the High Court, if the parties are not given the opportunity to adduce the evidence, and considering in the light of the facts that there is a dispute between plaintiff number 6 and the other plaintiffs, and it is a contention that the plaintiff number 6, contrary to the orders passed by the court that not to create any third party rights, had sold the properties in favor of several persons, and all those persons are already brought on record.
Defendant number 1, my lords.
Basing on the applications filed by the plaintiff. In these facts and circumstances, in spite of the fact that the PW6 has led the case and has adduced evidence on behalf of the plaintiffs, in the facts and circumstances of the changed, in the changed circumstances and in the facts and circumstances of this court, of this case, this court is passing the following order. The order dated so and so passed in IA number 49 and 50. 49 and 50 is set aside. When is the matter coming up?
My lords, I will take it up today afternoon itself.
That is
Seven.
seven.
7th it is posted, my lords. I will
Seven,
file
this
a board
Saturday
application, my lords.
on 7th, the PW2, that is the plaintiff number 1, the examination in chief, shall lead the further evidence.
Yes, my lords.
And on the same day, all the defendants are at liberty to cross-examine the plaintiff.
Yes,
And
my lords.
everything shall be concluded, all these
Yes,
things.
yes, my
On
lords.
7th itself.
Yes, my lords.
Yes.
On 7th itself.
Obliged, my
But
lord.
there are so many defendants, my lord. Even if all the defendants ask one question, they will not be able to complete the cross-examination.
On 7th and 8th, consecutive days.
8th is a Sunday, my lords. 7th is Saturday.
7th and 9th.
Seventh
May
and
be
ninth.
recorded and also it may be recorded that.
Huh?
Sixth and 7th may be directed, my lords.
Huh?
May be kindly recorded that.
6th
trial
and
court
7th it
record
may be
evidence.
directed.
May be recorded that the trial court shall consider the evidence on 7th and 8th. And thereafter, my lord, hear the matter and dispose of within a time frame because already.
6th and 7th.
6th and 7th.
Seventh already.
Seventh.
Seventh is already
Seventh
posted.
is
It's already
posted.
posted before the trial court on
We'll
7th.
take it upon
Next
6th
day
and
is
6th and 7th may be
Seventh and
directed.
ninth is eighth.
Eighth is
So it is 6th and 7th. 6th
Yes.
and 7th
6th and 7th.
shall be concluded, and immediately the matter shall be posted for arguments, and within a period of 1 month.
Now the impugned order, my lord, states
Defendants
that
will also
PW1
have to
shall-
be given an opportunity for evidence.
Let my friend wait. Now the
That's what I said. Yes.
impugned order says, my lord, that PW1 shall present himself for further examination.
Hmm.
That would also be there, my lord, after that.
Because I number 48 is.
Whatever is the evidence,
Yes.
whatever the formality
Yes.
to be completed in 2
Yes.
days.
2 days, yes. That,
On 6th and
Yes,
7th,
yes.
the entire evidence
Yes.
shall
Yes,
be
ma'am.
completed. Then the matter shall
Yes.
be posted for arguments, and within 1 month from 8th, the 8th or 6th, from 1 month from 7th, the matter shall be disposed of. Already the court's time in December is over.
yes, yes.
Yes.
Yes. Yes.
Obliged.
Obliged, my lord.
Much obliged, my lords.
If your lordship permits,
Number 12.
if your lordship permits, my objections may be noted and cost may be imposed on them. Since for these many years they have dragged on this
When did
matter.
you come on record?
Your lordship.
My
in
lords,
the-
they've come on record only in
when they
2025.
implemented on the. When they,
Please wait, when did you come on record?
when they,
And
when
what
they,
is the time?
disagree.
That is for the defendants to say, not to you. Yes,
My objections may be noted in that order.
yes.
Seal number 12.
My lord, the petitioner has challenged annexure F, my lord. Annexure F.
What is annexure F?
My lord, the order passed by the respondent rejecting.
No, everybody wants the contested matters to be in the preliminary hearing.
Yes.
If they are kept in the preliminary hearing, this is the result. At 12:30 also, you will not be able to complete 12 matters. Yes,
My lord, the petitioner is a purchaser of a property situated in cantonment area.
let
my
me
lord.
look at the prayer. Please come to the prayer. first.
Yes. Seeking a writ of certiorari to quash the impugned order at annexure F, my lord.
Who is the respondent number 3?
Respondent number 3, my lord.
What is the order passed by respondent number 3?
Yes. My lord, respondent number 3 is the authority which gives a permission for purchasing the property in cantonment area, my lord. There are, my lord, the rules regarding prior permission is not published in any of the law books relating to the cantonment properties. And therefore, in the year 2020, application filed by the petitioner was rejected. And that came to be challenged before this honorable court in writ petition, my lord, which is at annexure B, my lord, in WP number 10289.
What is the order passed by him?
My lord, now they say that ex post facto permission cannot be given. My lord, now the government of India has issued a circular on.
We'll ask them to come. Who appears for this defense?
My lord, defense MB Kanvi.
So and so is directed to take notice on behalf of.
My lord, for a moment, my lord, as far as the rules are concerned, the government of India itself has issued rules.
No, it is a case where once they come, you can have a final disposal.
Yes.
The respondents 1 to 4, so and so is directed.
My lord,
to
for
take
4, there is a separate advocate.
1 to 3, so and so is directed to
Yes.
take notice. 4 is?
4 is one.
Give it to the
I
court.
will give the name of the advocate.
4 so and so, and they'll counsel the petitions without a copy of the writ petition on the councils. Let's just matter on 16. 16. Yes.
Seal number 13.
VM
Yes.
Shilwant, 30, VM Shilwant.
Order of the Regional Provident Fund Commissioner is under challenge, my lords. They claim that I am due to the tune of rupees 6,32,000. But it was during the COVID period. My lords may kindly see page number 28 of the order. The impugned order is at page number, Annexure C, page number 25.
Page number?
28 may kindly be seen. This is the amount they claim that is due. Consolidated EPF contribution due statement. That is due. It is during March, April 2020, March 2020, May 2020, and June 2020, and all these things.
When is this order passed?
23, my lords. 26/5/2023.
26?
5/2023.
23?
26/5/2023. Thereafter, they assessed that I am liable to the tune of rupees 6,30,000.
Why are we hearing the writ petition in 25? of
Uh,
an
there-
order?
Thereafter, Annexure E and F were issued. That is recovery warrant and arrest warrant.
That would follow.
Arrest warrant.
Why have you not questioned this order
Uh,
for
uh,
2 years?
After issuance of arrest warrant, I came to know about this order. my
Then
lords. That is,
we will wait for the respondents to respond on this. We will not interfere at all.
I'll stay, at least stay,
Not
my
at
lords.
all,
Because
not at all. You are not entitled for.
my lords may kindly see for a moment, page number 29.
First, you have to cross the step 1. When an order is passed in the year 2023, asking you to pay the amount within 15 days, you have waited till 2026. Those are all the steps which are consequential steps.
That is, there is also reason for that, because
Consequential steps, you are not concerned.
I was
You are
not dealt.
concerned with the main order.
I was not well, my lords. Annexure D may kindly be seen. I was admitted to the hospital.
Who appears for the respondent?
PV Gunjal appears, my lords.
Yes, print the name of so-and-so. So-and-so is directed to take notice on behalf of all the respondents.
Please, my lords.
For respondent.
Both respondents.
1 and 2, the petition shall serve the copy of the writ petition on the council. This is matter on 11th of February.
7th. Seal number 14. PG Nargu.
Yes.
Matter pertains loan matter, lordships. This is a loan matter, lordship. Now, in this case, now the petitioners have purchased, not they borrowed the loan from the second respondent society, lordships, for their business purpose, lordships. In fact, they have paid them some installment amount to lordships. Subsequently, they become the defaulter, lordships. Therefore, the second respondent society raised the dispute before the first respondent under section 70 of the Karnataka Cooperative Society, lordships. Not the first respondent, without not giving opportunity to the petitioners, lordships, passed ex parte the judgment and award, lordships.
What do you mean by not giving an opportunity? Notice is not served on you.
No, lordships. Ex parte award judgment award has been passed, lordships.
Lordship, it is observed in the appeal, Your Lordship, at page number 21. In page number 21, appeal, Your Lordship, they have preferred appeal before the appellate authority, tribunal, Your Lordship, wherein it was clearly stated at para 11 and 12, Your Lordship. Para 12, one perusal of the trial court records, it can be seen that the notices of
Where
the
are you
dispute
reading?
were
Para 12.
para 12, Your Lordship. 11, 12, Your Lordship, wherein clearly stated 12 duly served on the appellants and respondent number 3 and 4 as per the postal acknowledgements.
What is your answer to this?
Kindly press in the same page number 21, first line, your lordship. On perusal of the trial court records, it can be seen that the appellants are placed ex parte before the trial court, your lordship. Even after passing the judgment, the same was not communicated to the petitioners, your lordship. Therefore, they were not aware of the.
Oh, please understand, number 1, whether notices are not served
In fact,
or not.
in fact, the
First you
notice.
answer that.
Please not.
Served on you.
Please, your lord. Notice is served.
So that ground is not available to you.
Please.
What is the next ground?
In fact, they were not aware of the judgment and the award passed by the first respondent, your lordship.
If you don't appear, how will you know? That is not a ground.
It's a mandatory under the Karnataka Cooperative Society Act, even after passing the judgment and award, it has to be not communicated to the petitioners, your lordship. In fact, after passing the judgment and award, it was not communicated to the petitioners, your lordship.
So
Therefore, they were not aware of the
latches on your part. You try to depend upon the technicalities. Now, what will you do? If an order is passed, we have not contested it, they have passed an
Now,
order.
Lord, the second is for Lord, the file the execution petition, Lordship. Now, they are ready to pay, not deposit some amount to Lordship. Loan amount,
What is outstanding?
Lord, the loan amount is 3,11,000, Lordships.
How much you are ready to pay?
Not the ready to pay, not the 1 lakh rupees, not. They in fact they have deposit some amount to installment amount they have not the paid.
You have taken loan, you owe the amount to the respondent. All these are all technicalities.
In fact, they are
Only
not the.
tell court when you are going to pay. On that, I will accommodate you on that. There is
In
nothing
fact,
on the
they have
merits
paid
of
the
the
some
matter.
installment amount to Lordships. Subsequently, they may not become the defaulter Lordships. Therefore, now they are ready to not deposit not the 1 lakh rupees Lordships.
Then after that, what will you do?
Pardon?
After that, what will you do?
Then not-
Deposit 1 lakh.
Please, Your
After that, what should follow?
In fact, not the interest, not the rate is not imposed on the not is on the higher side Lordships. Therefore, some negotiations not.
You come with the calculation. Come with the calculation before the court.
Yes.
Then we will consider.
We'll negotiate it Lordships.
Huh?
We'll ne-
Negotiate and come.
But in the meantime, not they have filed the execution petition Lordships.
Grant any interim order, you please come up with some positive, what is the amount, what is the calculation, and come up with a undertaking when you are
In
going
the
to.
meantime, they are not ready to deposit 1 lakh rupees within 6 weeks Lordships. Therefore, they have filed the execution petition Lordships.
I will pass an order on a comprehensive order considering all this. Yes, next.
Notice,
This
Your
is
Lordship.
matter.
In fact, not the
Takes notice.
Respond number 1.
this one number 1 Lordships.
Respondent number 1, HCGP takes notice. Respondent number 2, issue notice.
2 and 3.
2 to 4.
2
to 4 Lordships.
2 to 4 petition is permitted to take out hand summons and file a memo. In addition, issue notice to them.
Please, Your Lordship.
Yes, next.
Bill number 15, 16 urgent, seal number 17.
Yes.
Viva Sagade.
Yes.
My request for grant of BH series registration has been declined, my lord, on the ground that I am servant of a private bank. But I have produced documents to show that I am in transferable job and I am squarely covered under the notification, which makes private bank employees susceptible to transfer also eligible for BH registration.
As per Annexure C, my lords, the officers who are the All India services, and my lords, the central government employees who have transferred from state to state another, and also the bank officers who are also having my lords, the interstate transfers. The bank officers also comes under this. And in class 3, my lords, it comes. Annexure C, my lords.
Page
In
number?
Kannada, my lords, page number 14
So according to you, he is entitled.
is entitled.
What is this web? What are these rules? What are these notifications?
Yeah.
No, you're referring to some notification. What is it?
Yes, notification is, my lord, that was issued by the state government. I have made it part of the record
Number?
subsequently filed.
Subsequently.
Yes.
In
There is-
partial modification to the notification issued.
Yes,
so and so.
yes, yes.
Permission is accorded for the registration of non-transport vehicle. Service series only for the following employees who own vehicle. Officers of the All India Service, employees of the central government in the post of interstate transfer, officers of the bank in the post of interstate transfer. Who are you?
I am a bank employee, I mean, my lord,
Working in which bank?
ICICI Bank, my lord, as an officer, and I am liable to be transferred interstate.
Yes, the present petition is filed, seeking the following pair. It is the case of the petition that the petition is employed as a manager with ICICI Bank Limited, a scheduled private sector bank having pan-India operations with offices in more than 4 states. And the petition is liable for interstate transfer during their service. The petitioner had requested the respondents to grant the BS series registration, but the respondents by endorsement dated 8/12/2025 has rejected the case of the petitioner. What did they say?
It
I
says,
mean,
What did they say?
they said that I am an employee of a private bank, therefore not eligible.
It was rejected, stating that the petitioner is an employee of the private bank and is not entitled for the registration and a BS series. Then counsel appearing for the petitioner submits that The Government of India Ministry of Road Transport and Highways introduced the BH series vehicle registration on the central motor vehicle routes to enable transferable employees to retain a single vehicle registration. The petitioner has purchased a vehicle on 29/10/2025. Along with that, he has submitted a valid employee certificate issued by the ICICI Bank Limited, certifying the petitioner's employment. Land Council has drawn the attention of this court to the notification issued by the government of Karnataka dated 4/8/2022, which states that in partial modification to the notification number TD 276 TDO 20/2021 issued on 30/11/2021, permission is accorded for the registration of non-transport vehicles under BH series for the following employees owned vehicles, and in that at serial number 3, officers of the bank in the post of interstate transfer were mentioned. Land Council submits that petitioner being in a managerial cadre is and it's a transferable job interstate, as the bank is having operations in 4 states. Learned the AGA representing all the respondents 1 to 4 does not dispute the fact that the government has issued the notification dated 4/8/2022. As per the same, the bank employees who is in the post of interstate transfer are entitled for the registration of the vehicle under BH series. Next para, having heard so and so, there is a material on record. This court has perused the notification dated 4/8/2022 issued by the government of Karnataka, where it's serial number 1, officers of the bank in the post of interstate transfer are covered. The petitioner is a manager and the ICICI Bank, as it is stated, that is operating in 4 states, and as it is a transferable job, the petitioner is entitled for the registration of his vehicle under the BH series. Accordingly, this court is passing the following order. The proceedings stated. What is the date that notice? What is their proceedings stated?
These are 8/12/2025.
The proceedings dated 8/12/2025 is set aside, and the respondents, which respondent?
The 4th respondent is the one who registers.
The 4th respondent is directed to register the petitioner's vehicle under the BH series. Petitioner's vehicle, Hyundai, whatever in the paragraph prior. Accordingly, the petition is allowed. Yes, next.
Bill number 80, Sanjay Katigeri.
Yes.
Hotel Asteli.
Lordships have directed the trial court to verify whether compliance of.
Where is the report?
Yes, we have not seen the report.
Where is it?
Report is kept below is stated.
This is the report. Where is the report?
Yes.
Open it.
They have weighed the things directly.
Let us look at the report.
Yes, no, they have intimated the. Yes.
Report is self-explanatory.
Yes, sir. They have intimated both the councils to be present at the post office. That was.
Where is the order?
Yes. 29-1. Impugned order.
The document that are sent by
Please.
you are copy of the IA filed under Order 39, Rule 1 and 2, 1 page, affidavit, 2 pages. The documents that are required to be sent as per Order 39, Rule 3A and B or CPC with the petitions are listed below. A copy of the plaint, a copy of the affidavit filed in support of the application, copy of documents on which the applicant relies, memo with copy of IA filed under Order 39, Rule 1 and 2 and affidavit. Total 1 to 71 papers. The postal authorities have endorsed that if all the requisite documents are to be sent through the RPAD, the postal consignment ought to have weighed at 450 grams, but the compliance memo on the postal that is furnished by the plaintiff shows that the postal consignment is weighing only 20 grams. The documents that are sent by the plaintiff do not contain the plaint, which consists of 24 pages, and document on which the applicant relies upon runs up to 50 pages. The plaint copy and the documents are not sent by the petitioners as required under Order 39, Rule 3 of CPC. It is submitted that the compliance memo furnished by the petitioners and the postal receipts enclosed depict that the petitioners have not complied with the provisions contemplated under Order 39, Rule 3A and B of CPC. The said report is furnished for the kind notice of the Honorable Authority as directed by the Honorable High Court so and so by its order dated 29/1/2026. The following documents are enclosed with this report for the kind perusal of the same.
Yes. Yes. They are not, but in fact, they, in the postal, with affidavit, it filed everything, my lord.
What you are very
Your lordship.
vehemently arguing,
On
vehemently
the-
submitting that there is something wrong with the court without even having the correct instructions from your client. Now, for this, your client will pay. I have already passed an order.
Yes, your
Now
lordship
I'll
has-
impose 50,000 costs and dismiss your petition. Get it?
Yes, your lordship, once, if your lordship kind permission, because as per the affidavit file,
When I am repeatedly saying that,
yes, yes, my lord.
have been careful in accepting this.
So I made submission only on the basis of the affidavit, they,
Then a judge, the interim, the judge of the trial court is directed to send a report to this court as to whether the petitioner has filed all the documents as required under.
yes,
so
yes,
and
my
so.
lords,
The interim injunction that is granted by the trial court shall continue so and so.
yes.
Yes.
My lord, I have made submission because annexure J, my lord, they issued the certified copy, if your lordships may, in the order, which say that they have complied, page 113, my lord.
But the judge has
Yes,
said
my lord,
it
your
is
lordship
not
say-
complied.
Yes, yes.
When the judge said it is not complied, it's your duty.
No,
to
of
give
course, yeah.
Your client has given you wrong instructions.
No, client would be there or counterpart would be.
Whoever it is,
Yes.
they have to, then it has to, and the order is also there.
Yes,
So it's okay
but,
with you.
yes, second, my lord, would be there. Of course, trial court would not have what they have submitted now, my lord. If that was stated, my lord, I would not have filed.
Knows what he has sent.
He says that,
Knows what he has sent.
yes.
Now, your postal acknowledgement weighs about 20 grams.
Yes,
What are the documents? 70 grams, 70 pages are the documents, which you are supposed to sell as the complaints of
I
order
think, yes,
39, Rule 3A and B.
yes, I think partially they might have complied it.
That is what it is. Then why a revision, why a petition is filed on that?
Yes.
When you are not complied with, when an order is passed, then why should it be?
Only on the ground, my lord, affidavit is filed, 100-page annexure J was produced, where, my lord, they,
I'm telling.
yes, ma'am. Your lordships are,
Every advocate has some responsibility.
Yes, yes.
Towards the court,
Yes, ma'am.
being an officer of the court.
Yes. I made submission, my lord, on that affidavit itself, my lord.
Now,
Yes.
first of all, no, I'll do one thing.
Yes.
For filing a frivolous petition without even, without even complying with so-and-so and filing a petition before this court, let us see your grounds. You must have stated so.
Kindly see, my lord, page 112.
Now, on and off, if
Yes.
we impose costs, at least the scrupulous litigants will understand that they can't waste the court's time.
Of course, my lord. The file was that, my lord, annexure J was stated in the affidavit, my lord. Very next day it was filed.
That the trial court has not considered or discussed the reasons for vacating the ex parte
Yes.
temporary interim order when the petitions are filed affidavit with postal receipts regarding compliance of order 39 rule 3 of CPC. Hence, the impugned order under annexure L is vitiated.
Yes. Yes.
The petitioner has specifically contended regarding compliance of order 39 rule 3 of CPC when the temporary injunction was granted during so and so. So at every paragraph, at every ground, the same thing is reiterated. What is to be done now?
Yes. My lord, may kindly, I will not take much time, my lord's waste of 112, kindly see, my lord, pay. Annex. They filed affidavit, my lord.
Yes.
This submission was made.
This is not sufficient.
Yes.
Without doing it.
No, annexure J, my lord, page.
Looking at 1112, 112.
Yes, next page, my lord, affidavit is 113, my lord. They stated para 3, then, my lord. Para 3 and.
No, that is what it
Yes,
is.
ma'am.
Without doing it.
Yes, ma'am. Of course.
No, your client has signed it. The
Yes,
deponent
ma'am.
is there.
They with affidavit,
For
ma'am.
making misrepresentation
Yes.
before the court.
It is not that myself was not.
Not you.
Yes.
Please don't think that you. What
Yes.
is that you will do?
Yes, ma'am.
Your client,
Because-
when I'm saying you means your client,
Yes.
not you.
Yes. And in fact, my lord, I secured the certified copies because the office copy I did not go. Your lordships get those are certified copies. Thereafter only I verified, yes, it is come. Your lordship.
Client has to face the.
Yes, my lord, my lord, since they are all handicapped person, the institution respond defend, they are all the members of handicapped society. So respond number, defend number.
Because the
Just, I am not saying anything more, my lord.
Not give them any right to.
Yes,
not
ma'am.
play with the system.
Yes, no, defend number one is society as a registered society. Some defendants acting against the interest of that society. So these people approach the court, my lord, for declaration and other relief, my lord. And in fact, they came with wheelchair and all this. So I request your lordship, I'm not saying.
No, court has all the sympathies with them.
Yes, ma'am.
Because
Their conduct itself.
you're physically challenged or
Yes,
disabled,
ma'am. All
doesn't
of
give
them.
you any right to make these kind
Yes,
of submissions before the
of
court.
course,
And literally on the last occasion today.
Yes,
so,
ma'am.
like some time of the court is wasted for no reason.
Yes, your lordship put
This
an.
petition is filed.
Yes, your lordship put a rider with that itself on that day.
What rider?
A rider that if it comes to the knowledge of the court that you have not complied, a cost would be imposed, your lordship. Has stated in the order itself only on that.
I've already said.
Yes,
This
ma'am.
writ petition shall be dismissed with
Yes,
cause
yes,
of
my lord.
52
Yes, yes.
by the petitioner to the respondent if the
Yes,
court
yes.
receives a report from the learned judge
Yes, yes.
that there is no complaint.
Yes. My lord, I would say some 20-25,000 maybe reduction. I will not say anything much more.
Anyhow, we will dismiss the writ petition.
Yes. My lord, second writ petition may be de-linked, my lord.
First let us pass order. In
Yes.
This is WP number 10024. The present writ petition is filed. Agreed with the orders passed in. Where do you get that?
My lord, it gets in the prayer, my lord, page 16, your lordship may get.
No, order.
Order, your lordship, 146, my lord. Page 147, my lord.
Agreed with the order dated 10/11/2025. Cast in voice number 606. Dated 606 of 2025. By the 5th edition civil judge and JMSC Belgavi. Whereby No, that's not the order, I think.
Page 147, my lord.
146 and
That
146.
is at,
Last
the
yes.
order is dated,
Dated, it is, my lord, continuation is there.
no. This order is dated 28/10/2025, I think.
Yes, 2810. My lords may get, this is on,
What is the date? What did you mention in your prayer?
the order is on, my lord, 29, my lord.
For 29/10/2025.
Yes.
Asked so and so, so and so. The plaintiff is before this court. The court, the plaintiff has filed the suit for declaration.
Yes, declaration and injunction.
Declaration and injunction. In that he has filed an IA seeking temporary injunction. Initially, temporary injunction was granted. Thereafter, by order impugned, the said order is vacated. The court, while vacating the interim order, has observed that the provision of order 39 rule 3 of CPC is mandatory provision, and the complaints in respect of the said provision cannot be made partially. It has to be complied in strict adherence to the statutory provision, which is not made by the plaintiffs in the suit. It is to be noted that the plaintiffs have obtained equitable relief of injunction, and as rightly referred to by the counsel for the defendant number 1 to 5, 7, 8, and 10, as decided in the judgment of the Apex Court in AR 2000 SC 3032, the complaints of mandatory provision is condition that is essential to be complied with. The court observed that the petitioner has not complied with the same. As such, the interim order that is granted, the interim injunction granted is vacated. Learned counsel appearing for the petitioner submits that the petitioner has complied with the same, and he has sent all the documents, the next the documents, and the order impugned needs to be certified. Learned counsel appearing for
Respondent number 1, defendant number 1.
only one defendant.
No, sir, I had filed a caveat, but only for defendant number 1 it is put up now.
So you're appearing for all defendants.
No, sir, defendant number 1.
You appear for
11 minutes. Respondent number 11 minutes in the petition.
the counsel appearing for defendant number 1 and defendant number
Before trial court, my lords, I appear for defendant number 1 to 5, 7, 8, and 10.
1 to
1 to 5, 7, 8, and 8.
1 to 5, 7, 8,
and 10.
and 10.
Appear for 11 minutes. 11, defendant 11.
And 11, the counsel submit that when there was non-compliance of order 39, rule 3, which is mandatory in nature, the court had rightly dismissed has rightly vacated the interim injunction, and there are no grounds to interfere. It is submitted that that there are no reasons to interfere. Next part. When this matter came up, when the learned counsel has stated that they have complied with order 39 rule 3, then this court has called for a report from the trial court, and the report is placed before the court stating that the petitioner has sent the RPAD, which is weighing about 20 grams, whereas as per order 39 rule 3A, he has to send a copy of the plain, and that is running into 1 to 13 pages. A copy of the affidavit filed in support of the application, that is 2 pages, and copy of the documents on which the applicant relies, that is ranging from pages 17 to 67, and memo with copy of IA filed under order 39 rule 1 and 2, and affidavit, that is 3 pages. Total, there are 71 pages, and the learned judge has obtained the endorsement from the postal department, and as per the same, these entire documents would weigh around 450 grams. It is stated, in the report it is stated that there is no compliance of rule order 39 rule 3. This court in the earlier order has observed that if a report is placed before the court stating that there is no compliance of rule 3A order 39 rule 3A, the writ petition would be dismissed with exemplary costs of rupees 50,000. Next para. Learned counsel appearing for the petitioner submits that the petitioners is a society of handicapped persons.
Yes. Yes.
And as there is an interference as interference oblique mismanagement by the respondent. They have filed they have filed the suit. It is submitted that it is if a cost of rupees 50,000 is imposed, it would be very difficult for them, and this court may consider the case of the petitioners, and it is submitted that he will instruct them that they shouldn't indulge in these kind of things in future. Next para, having heard the learned counsels on either side, there was a material not recorded. The court has vacated the interim injunction as there is no compliance of Order 39 Rule 3. It is also, and there is no dispute about the fact that Order 39 Rule 3 is mandatory in nature, and that the strict compliance of the same has to be, there shall be a strict compliance of the same, and there is no go by to that. In the light of the report that is placed before the court, it makes it crystal clear that all the documents are not placed are not served as per Order 39 Rule 3. In that view of the matter, this court do not find any reasons to interfere with the order impugned. This court has passed an order saying that if the report is otherwise, and the cost of rupees 50,000 will be imposed. This court has considered the submission of the, not this court, the submission of the accounts for the petitioner that it's a society of the handicapped persons, as such a lenient view has to be taken. This court is of the view that because they're physically handicapped persons, it would not give them any right to misrepresent the facts before the court. When a party is coming to the court seeking a relief, they should come before the court with clean hands. And the persons who come to the court with these kind of suppression of facts, or this amounts to misrepresentation before the court. It is cautioned that if in the future if this kind of an attitude or this kind of suppression is found by the court, the trial court shall take appropriate action against the petitioners. Accordingly, the petition is dismissed. Next petition.
Next petition.
Yes.
Undertake to appear on behalf of defendant number 1 to 5. I appeared for only one. I request a short date. I'll file a power for remaining. It will be taken on Monday or Tuesday.
So undertake for.
This matter on Tuesday.
Yes, please.
At the request of respondent. Respondents 1 to
5.
1 to 5 for filing
7
wakalat.
wakalat and 10.
I undertake for 11 minutes, I'll file.
And then counsel so and so submits his instructions to file wakalat on behalf of.
Please.
You already filed?
No, I undertake to file it.
For
both matters.
respondent number 11.
Please.
Yes, next.
Seal number 19 to 22 adjourned. Seal number 23. Girish Yadwad, Anil Kale.
Appearing for the respondent.
Yes.
Petitioners are the defendants, my lords.
Yes.
Suit for position. My application for court commissioner was rejected, my lords.
Your application for
Court commissioner was rejected, my lords.
was rejected.
Please, my lords.
Respondent. Appearing for the respondent, my lords. There is another suit, my lords, which came to be decreed between the same parties, my lords. Plaintiff is the same, respondent is the same, my lords. OS 70 of 2015, my lords.
OS 70 no?
70 of 2015, my lords.
What is the suit for?
Suit for possession, my lords, as in same case. Suit for possession, my lords.
Was declared.
It was also a
Was
position.
decreed when date?
It was decreed, my lords. And as against that, my lord, they have also filed a RFA. The RFA is also dismissed, my lords. The plaintiff, my lords.
Then you have not filed an application under Order 7 Rule 11.
In that, my lords, it has been filed, my lords. And in that, my lords, some other properties, my lords, adjacent to these properties, commission report was filed, my lords.
No. OS number 70 of 2015 is a suit for possession.
Possession, my
It
lords.
is decreed.
Decreed, my
When?
lord. Yeah, 2022, my lords.
2022. Against that, they filed a first appeal.
First appeal, my lords.
That is also dismissed.
That is also dismissed. And
Then
the
how
proper.
can- And what is this?
No, my lords, what has happened, it was totally consisting of 5 properties, my lords.
Oh, the first suit.
In first suit, 4 properties, and this suit, my lords, 1 property for possession. 1 property, my lords. And in that suit, my lords, a commissioner was appointed, my lords. And the commissioner, my lords, has given a report stating that this property also belongs to the plaintiff, my lords. In that suit itself, it has been declared, my lords. And it has been, the extract has been given in the first appeal, my lords.
Let's come to the order. First, let's see the impugned order.
Please.
Come to the reasoning part, paragraph number 6.
Please. Mary.
Yes, please read.
At the outset, the plaintiff has filed a suit against the defendant for the relief of recovery of possession. The defendant, through the application, intends to get measure the suit schedule property, contending that the plaintiff has filed a suit for declaration and possession. It is not declaration, my lords, it is for only for possession. On the PT sheet prepared by Taluka Surveyor on the file of OS 70 of 2015, and plaintiff succeeded. The plaintiff again intends to take the possession of the suit schedule property on the basis of alleged PT sheet. The Taluka Surveyor has not prepared the PT sheet as per the government circular, and the plaintiff has not followed the condition imposed by the government. Therefore, it is necessary to get the measurement of the suit schedule property by appointing ADR as a court commissioner for adjudication of matter effectively.
In the present suit, only one property is there.
One property.
Which property is not part of the earlier survey?
Earlier survey number, my lords. But in
What is the bearing of that to this?
no, my lords, and the commissioner, my lords, has given a report, my lords, stating that all the properties, my lords, belong to the plaintiff, and the defendant property is adjacent to this property, my lords. May I first up?
No, he has given a report.
Please.
Unconnected. No, he will be giving a report
Please,
for the
please.
properties which are part
It was
of
in
the
this
suit.
OS 70 of 2015, my lords.
According to you, there are 4 properties.
5 properties, my lords. Five.
And this property is not part of that.
And not
so
part
if
of-
this is not the part of that, why would he give a report for this property?
No, my lords, what has happened, my lords, is that this suit, my lords, is filed prior to that suit, my lords. This suit, why? Because this suit again renumbered in the year 2021.
Let's read further. Please further read.
And effectively, in order to know whether the plaintiff is the owner of the suit schedule property or not. On the other hand, the plaintiff has resisted the application stating that the instant suit is filed by the plaintiff for relief of possession of suit schedule property. The defendant constructed tin shed in the suit schedule property without the notice of the plaintiff by encroached upon suit schedule property. After the knowledge of the encroachment, the plaintiff moved the HUD bus measurement of the suit schedule property, and the city survey conducted survey on 21/10/2014 and shown in the encroachment by defendant. Being aggrieved the conduct of defendant, plaintiff filed OS 70 of 2015, wherein the court commissioner submitted a report in 2018, and the instant suit is filed based on the encroachment report. The said report was not challenged by the defendant, so it was final and conclusive. The defendant in his affidavit contended that the present plaintiff succeeded in OS 70 of 15 and now again intends to take the possession of the suit's property is based on the alleged PT sheet is denied in total. When the PT sheet is denied by the defendant, appointment of commissioner for measurement is not maintainable. OS 70 of 2015 decreed in 2020 by a judgment, the defendant preferred RA 10 of 2020, which was partly allowed on the ground of jurisdiction. As per the judgment and decree in RA 10 of 2020, the instant suit is filed. The defendant, in order to keep alive the instant issue, has filed this instant application just to protract the proceedings, as it is more than 10 years old issue. The defendant is attempting to delay the proceedings, hence prays to dismiss the application. After hearing the both side and perusal of materials available on the record, it is pertinent to note that the plaintiff has clearly described the boundaries, exact location and extent of the suit schedule property in the plaint. The identity of the suit property is not in dispute. The suit is for recovery of possession based on the encroachment made by the defendant. The defendant has not produced any clinching document to demonstrate either ambiguity or confusion regarding the property in question. It is well settled that court commissioner cannot be appointed to collect the evidence or to fill lacuna in the defendant's case. The measurement of the suit schedule property as sought by the defendant in this case amounts to a collection of evidence. Further, there is no any ambiguity either in the description of the suit schedule property nor in the identity of the suit schedule property. Moreover, the defendant seriously disputed the PT sheet prepared and filed in OS 70 of 2015, on which the present plaintiff relayed on claimed the possession of the suit schedule property. On perusal of the defendant's written statement and on other materials, it does not reveal that the defendant has not at all challenged the PT sheet before appropriate forum. That apart, the defendant clearly contended that OS 70 of 2015 filed by the present plaintiff was decreed in his favor, and aggrieved by the same defendant, preferred RA 10 of 2020. In the present facts,
Why, no, if the plaintiff has filed the suit, it is for the plaintiff to establish and prove that there is, is entitled for the relief. Why do you want the appointment of the commissioner?
My lords, there is some ambiguity here, my lords. In the OS 70 of 2015,
Forget about it. That is his burden,
ma-
isn't it? It's a
they
burden
are,
of the
they are
plaintiff.
pleading encroachment, my lords, that have encroached in their land.
Correct.
Please,
That
my
he
lords.
has to prove it. He has to prove it
They are, it is based on the PT set in 2015 OS, my
where
lords.
is that the court said it will consider it? Where did the court say?
Reason is, earlier, my lord, he relied on the petty sheet. Then after the court commissioner filed a report in the other suit, my lord, he got his pleadings amended. Now he wants to again rely on the petty sheet. Therefore, there is clear case of
That
ambiguity.
stage has not come.
Now
Whether
my
the court is, no,
now-
when the court is considering it,
Yes,
you could as well say, as he said, the properties are 5 in number. This number, this property is not part of the
No,
commission's
that is
report.
one aspect, my lord. That is, there is no doubt about that aspect. Now, by dismissing my application, my lord, the trial court,
File an application is the
because the trial
question.
court wants to rely on the same petty sheet which he relies.
You can't anticipate on what the court is going to do. If it relies on it, you have your own remedy.
So my case is that, my lord, I have not encroached any portion of his property.
You don't have to say that. When he say that he has, you have encroached, that is for him to prove. How he will prove is his problem. Please come.
That observation may be made, my lord, in the
Huh?
course of this order. That observation may continue,
Yes.
because the trial court doesn't take that into consideration.
Agreed with the order passed in I number 6, invoice number 142 of 2021, dated 10/12/2025. The defendant is before this court. The respondent herein has filed a suit for possession. In that, the defendant has filed I number 6 under Order 24, Rule 9, read with 151 CPC, to appoint the Assistant Director of Land Records as Court Commissioner for measurement of the suit property as per the memo of instruction. That came to be dismissed by the order impugned. While dismissing the application, the court has observed that the defendant has not produced any clinching document to demonstrate either ambiguity or confusion regarding the property in question. It is well settled law that the court commissioner cannot be appointed to collect evidence or to fill the lacuna in the defendant's case. Measurement of the suit's property as sought by the defendant in this case amounts to collection of evidence. Further, there is no ambiguity either in the description of the suit scheduled property or in the identity of the suit scheduled property. Moreover, the defendant seriously disputed the PT sheet prepared and filed in OS number 70 of 2015, on which the present plaintiff relied and claimed the possession of the suit scheduled property. On perusal of the defendant's written statement and other materials, it does not reveal that the defendant has not at all challenged the PT sheet before the appropriate forum. That apart, the defendant clearly contend that OS number 70 of 2015 filed by the plaintiff was decreed in his favor, and he agreed with the same. The defendant preferred RA number 10 of 2020. In the present facts, it appears that the measurement of suit scheduled property sought by the defendant is neither required nor relevant for deciding the possession of the suit scheduled property at this stage. Hence, the court had dismissed the same. Land counsel appearing for the petitioner defendant submits that the earlier suit, that is OS number 70 of 2015, a survey was conducted. It is submitted that in that there are 5 properties. Further, now the second suit is filed by the plaintiff. In this suit, the property in this suit and the property in the other suits are not one and the same. One and the same. The court cannot take the survey that is conducted in the other suit pertaining to the properties of pertaining to the other properties without a specific reference to this property, which is a suit scheduled property. It is submitted that they have filed the present application for the survey, as it would help the court, as the survey would reveal the true facts and whether there is any encroachment by the defendant or not. Land counsel appearing for the respondent plaintiff submits that when a sketch was prepared in the earlier suit between the very same parties and that litigation has attained finality, the defendant has not questioned the same. As such, the court had rightly held that the said aspect has attained finality, and this amounts to collecting of the evidence and rightly dismiss the petition. Petition as such, the no interference is called for with the order impugned. Next, having heard so and so. The respondent herein has filed earlier a suit for possession in respect of 5 properties. In the said suit, there was a reporter, a court commissioner was appointed, and a report is placed before the court. After that, the suit is decreed, RA is dismissed.
Yes, on some jurisdictional aspect, one point, my lords, for this property, RA is dismissed, my lords. And for other properties, RFA is filed and it was dismissed.
RFA is dismissed.
Dismissment, their
Dismissed.
RFA.
It is an admitted fact that this property is not part of the earlier suit. When this property is not, though there, it is between the same parties. When it is not the same property, the court will not consider the said report filed in the earlier suit. Then coming to the present application that is filed by the petitioner, defendant is concerned. When the plaintiff says that there is an encroachment by the defendant and he files a suit for possession, it is for the plaintiff to prove that there is an encroachment by the defendant. And it is not necessary that the defendant, there is no necessity for the defendant to file such application. In case if the court is considering the report that is placed, that is given in the earlier suit, that it is always for the petitioner to raise his objection, and once an order is passed by the court, it is always open to the defendant to question the same. In that view of the matter, this court do not find any reasons to interfere the order impugned. Accordingly dismissed.
Number 24.
Yes.
Bearing for the petitioner, my lords. A very small issue involved in this petition that, my lords.
Huh?
A small issue in this petition, my lord, that the petitioner.
Straight away come to your prayer.
Lord, petitioner car is, my lords.
We look at the prayer.
Please, my lords.
Yes. Directing respondents to release Kia Seltos diesel vehicle to the petitioner in the interest of justice.
Lords, why have been without any FIR, without any punching out, the same has been seized. After seizure, the same is required to be reported before the concerned magistrate, my lords.
Yes.
If the same is reported before the magistrate, I will go before the magistrate.
Annexure C may kindly be seen. Annexure C, page 14. It appears that it is stationed outside the police station.
Why?
I don't know why. I take instructions.
Strict instructions
Yes.
to tell them. Now, if you have seized the vehicle, then before with the concerned magistrate
Yes.
where it is pending, if you give the details, it will be, and it's your duty to do so.
Yes, yes.
Please, my lords.
I'll take it.
Without, making him go around the courts.
Yes,
It
I'll
is
take
the grievance
instructions.
of the petitioner that the respondent have seized the vehicle belonging to the petitioner. And thereafter, they have failed to follow the due process. If they have if the same is reported to the magistrate, the petitioner would get an opportunity to file appropriate application seeking release of the vehicle. Whereas in this case, the respondents are not, if the petitioner is completely, they kept the petitioner in complete darkness. Next para. In connection with any crime or for any reason, if a particular vehicle is seized, the respondents have to follow the procedure as contemplated under law. The petitioner ought to have been informed by the respondents what is the action that is initiated. It appears from the submissions of the learned counsel that unfortunately such a procedure is not adopted by the respondent. The learned HCGP who takes notice on behalf of the respondent, number 1, shall get specific instructions in this regard. List this matter on 16th of February.
16. Yes. Seal number 25. Shuraj P. Mudhod.
Yes.
Appear for the petitioner.
Quash the
My lord,
impugned order dated,
Annex 3, my lord, the impugned order, my lord,
passed by whom?
passed by the second respondent. My lord, the appeal filed by the petitioner against the order passed under section 68, appeal was filed under section 106 before the second respondent. Along with the appeal, I have filed in two applications, one condonation of delay, another is grant of stay. The second respondent authority, only one line, my lord, of the order, my lord, page 65, page 65, the case was called out, appellant was present and respondent absent. IA1 is allowed, IA2 is rejected.
IA1 is for?
IA1 for condonation of delay allowed.
That is allowed.
Allowed. IA2 for my lord, grant of stay is rejected. But this honorable court considered the issue when the statutory appeal is filed.
Yes.
At present, your lordship, notice has been issued, your lordship, after giving an opportunity, your lordship.
Questioning has to be there in every
Yes.
order.
Please, your lordship.
That is the heartbeat of any order. Why should he not? Why there
Because
is no
notice.
typist available to write type the order? We'll set aside this order and we'll remand it back. Let him consider and pass orders on.
Lord,
the
maybe
No.
one submission, Lord.
Inquiry.
This honorable court, Lord, considered this aspect, granted interim order of original order and directing the appellate authority to decide the appeal on merits within reason.
Not do all that. That is not at all the
Please.
jurisdiction of this court. We
Please.
will set aside this order.
Please.
Ask them to pass orders on your IA number 2
Please.
within a period of reasonable period.
Please.
The present writ petition is filed. The writ petition is filed seeking the following prayer. It's a case of the petitioner that the fourth respondent is a primary cooperative society. Who represents the society? I think notice has to go.
Please.
Please take out the hand summons on them. I'll pass an order.
Please.
Well, if you file it immediately, I'll list this matter whenever you can file. The
Lord, I pray for-
HCGP takes notice on behalf of 1 to 3.
1 to 3.
1 to 3, my lord, government.
1 to 3 were taken.
Then 4 and 5.
In 4 is inquiry officer is a government official. But if they want, my lord, let them.
Then
Other-
4, but
Fine.
I think you can take notice for 4.
He completed
also.
inquiry and
I'll
submitted
take-
a report. He ends the matter.
1 to 4, HCGP takes notice. 5, take out hand summons. Petition is permitted to take out hand summons and file a memo. Once, or else I'll give a date. If by the time you file it, will come. If the memo is filed, list this matter on 9th of February. I'll dispose this matter on the day.
9th February.
Yes.
Seal number 26.
Yes.
On behalf of Suresh Absabetti Lordship, the present petition available loan from the respondent number 2 Lordship from the Cooperative Bank. And they paid part payment Lordships. And the respondent number 2 filed a case before the respondent number 1 for GRCS. And they passed an order Lordships. Being agreed by that, the petition preferred appeal before the KT Lordships. The KT also confirmed the respondent number 1 order Lordships. Being agreed by that, the petition is filed Lordship. And now the petition is ready to deposit the amount Lordships.
What is outstanding?
The, as per the annexure A Lordship, 30 lakhs Lordship.
How much?
30 lakh 56,558. Already he paid 10 lakh rupees. Remaining 20 lakhs is there. They are ready to 50% deposit the amount. Lordship.
First of all, what is the matter on the merits of it? Why should we interfere? Then you can, then if it's a case of interim order, then we will think about it.
Yes, Lordship.
What is wrong with the order of the tribunal?
So, in fact, Lordship, though the deposited by the petitioner amount, the amount deposited by the petitioner, it is not considered and straightway passed an order, Lordships.
No, if your dispute is with regard to the calculation, you can come up, they'll get instructions. And if you want a timeline to pay the amount, we will grant that time. Please get instructions. Yeah, whatever is your dispute with regard to the calculation, give it to give it to her, she'll get instructions.
That is already considered, your lordship. What they are submitting, your lordship, 10 lakh has been already deposited. But that is adjusted with the interest amount, your lordship. That is already considered by the court. Your lordship.
That is Lordship,
Tribunal.
the matter be taken on Monday, Lordship. Yes. Matter be taken on Monday, I'll get the instructions. The matter be taken on Monday, Lordship.
Monday, pick up on Monday.
Yes.
Monday.
Fine.
Yes, much.
HCGP takes notice, sir, respondent.
Please, your lordship, respond number
Respondent one lordship.
One only, your lordship. One, only one, your lordship.
Only one.
Lordship,
The other
and-
respondents look at it, notice.
And 3 and 5 may be dispensed, lordship. 3 and 5 may be dispensed.
3 and 4 are the
3 and 5 also.
guarantor, your lordship.
Then you file a memo.
Yes, memo.
Memo is filed, second dispensation of notice to 3 and 5. Memo is taken on record and dispensed. So take the memo from him. Yes, 27.
Memo kodi.
Yes.
Bill number 27. Pawakan, SS Pawakan.
Wish to appear for the petitioner. I'm representing petitioner counsel minutes. Annexure A is the impugned order. Suit is minutes filed by the petitioner who is the plaintiff before the court below. Minutes after completion of both the plaintiffs and defendant evidence. Suit for specific performance of contract.
Where is the suit?
Part 2019 minutes.
Yes.
After completion of minutes, both the plaintiffs and defendant evidence, when the defendant has disputed her signature on the agreement of sale, he files an application for referring the agreement of sale for minutes.
No, has he not disputed it in his written statement?
Both in written statement and also in the evidence.
What
Minutes.
were you doing till the trial is completed?
Minutes now, minutes it is.
That should be done at the earliest point of time.
That's right, minutes. I concur with my lord's opinion. Minutes, here is the question. Minutes, when an agreement of sale is minutes presented before the court below, and the written statement signature is also available before the court below. Court below should have looked into it and it has come to a conclusion. If it is not in a position to, let's opine that both the signature differs, then it would have been referred to let's expert's opinion.
Let's see the order.
Let's order is at page, let's annexure A, page 13, that's paragraph 9.
From the reasoning part, we will read.
Let's read. It starts with let's para 9. As this court has already discussed that the present suit has been filed by the appellant plaintiffs against defendant for the relief of specific performance of contract, along with the alternative prayer for refund of earnest money and interest with cost. The applicant plaintiff is relying upon unregistered agreement of sale, and it is upon the plaintiff to prove the fact of execution of alleged agreement of sale by the defendant. On perusal of order sheet, both the parties have concluded their evidence and matter is posted for arguments. At the time when the matter was posted for arguments, the applicant plaintiff has come up with the present application praying for sending exhibit P1 to handwriting expert, which in turn causes delay in disposal of the matter. The present matter is pertaining to the year 2019. Both parties have took sufficient time to proceed with the matter. By considering the nature of suit, in the evidence available on the file of this court is sufficient to adjudicate the matter. This court does not find any sufficient reasons to send exhibit P1 to expert for opinion. This court, after completion of pleadings, framed issues, and on a careful perusal of the issues, the entire issues have been framed by this court by casting burden upon the plaintiff. As such, it is upon the plaintiff to prove the suit, and no issues have been framed by this court by casting burden upon the defendant. In respect of present matter, both the parties have concluded their evidence, and the matter is posted for arguments. On careful perusal of the entire file, this court finds that oral and document.
The thing is, why no this defense of the defendant is available right from day one when you
Yes,
file the written
yes,
statement.
ma'am. Yes.
Now you have left everything to happen. You have let the entire trial to complete, documents to at this stage. Why should you file this application? It is not that for the first time you know about this. So the court has rightly held that it is not necessary at this juncture. Please come. The present petition is filed, agreed with orders passed on I number 10 in OS number 40 of 2019 dated 5th January 2026. The petitioner before this court is the plaintiff in the suit. The plaintiff has filed the suit seeking specific performance of an agreement of sale. The respondents have filed their written statement stating that the signature is a forged signature and they have not executed the same. Then after the evidence of the parties are completed, at that time, this IA number 10 came to be filed. That was dismissed by the court by order impugned. While dismissing the order, the court observes that plaintiff is relying on the unregistered agreement of sale and it is upon the plaintiff to prove the fact of execution. On perusal of the order sheet, both the parties have concluded their evidence and matter is posted for arguments. At the time when matter is posted for arguments, the plaintiff has come up with the present application, praying for sending exhibit P1 to handwriting expert, which in turn causes delay in disposal of the matter. It is stated that it is observed that the matter is pertaining to the year 2019. Both the parties have took sufficient time to proceed with the matter. By considering the nature of the suit, the evidence available on the file of the court is sufficient to adjudicate the matter, and the court do not find any reasons to send exhibit P1 to the expert opinion. The court has further observed that the court does not find it just and proper to go to the merits of the matter. If suppose at this juncture the court goes to the merits of the matter, and if suppose the merits may touch, it is nothing but causing prejudice. However, the court do not find any sufficient grounds and reasons to allow the application by going through the application elements in the manner made out, for which the opinion of handwriting expert is sought by the appellant plaintiff, and accordingly the same was dismissed. When counsel appearing for the petitioner submits that when the defendant is denying the execution of the agreement of sale, the court ought to have allowed this application. And if allowed this application, if the court is not inclined to send it for the expert opinion, court also is competent to compare the signatures. At least the court should have taken up that exercise. It is submitted that in the light of the fact that the defendant is denying the execution of the agreement of sale, the court ought to have allowed the application that is filed with the petitioner, a petition of plaintiff. Next para, having heard the land counsel for the petitioner, there is a material non-record. The suit is of the year 2019. That suit is filed for specific performance of an agreement of sale. The said agreement of sale is denied by the defendant when they have filed the written statement in the year 2019. The petitioner is aware of the same, and right from 2019 till the entire evidence is concluded, petitioner has never sought for this exercise by the court. Now, when the matter is posted for arguments at this stage, the court cannot allow this application, and in the considered opinion of this court, the reasoning that is given by the court is just and proper, and no interference is called for. Accordingly, dismissed.
Grateful.
Yes, next 28.
Seal number 28. Sem Dharwad, 28. Sem Dharwad.
Yes.
Please. The suit for declaration and injunction filed by the petitioner, my lord. During pendency of suit, he filed an application for appointment of court commissioner. That application is rejected by the trial court, my lord. On the ground that, my lord, it's almost to collection of evidence.
What is the stage of the suit?
Suit upper previous evidence is not yet commenced.
Not taken place.
Not
No,
yet.
correct. At this stage, it is not required. When you lead the evidence, and when all the evidence is before the court, and at that point of time, that evidence is
Even
not
my lord,
sufficient,
before
then it
commencement
would
of
be
evidence also it can.
it would be a last resort.
It can be allowed. Since my lord, their word is for some petition is 72 years old.
First of
they-
all, your responsibility to prove your case. First of all, you have to adduce the evidence, whatever it is. When that as a last resort, the court can look into. What is the order of the court? Let us see.
Next, yeah, my lord. In fact, my lord,
No,
if
without
the
even
court
the
commissioner
evidence
is
being-
examined, my lord,
without the
whether the
court
petitioner is in
uses
possession
agency
or
to
respondent is possession, that will
Read
come
the
to.
order.
I am of the,
This court should not use its agency.
this court should not use its urgency to collect evidence in favor of or in against any party to the litigation. The plaintiff has sought relief for make local inspection of the suit property and to report whether the plaintiff is in possession or not. That the plaintiff and defendants themselves have to prove their case by adducing necessary documents before this court.
Yes, please come. The present petition is filed, questioning an order that's passed on I number 14 in OS number 168 of 2019 dated 3rd November 2075, 2025. The petitioner is a plaintiff. He has filed the suit seeking declaration and injunction. In that, even before the evidence is commenced, the petitioner has filed an application for appointment of a court commissioner to make a report whether the petitioner is in possession of the property or not. And also for the other details, the court by order impugned has dismissed the same, and while dismissing the same, the court has observed that the plaintiff has to prove the case by using necessary evidence, and he cannot depend upon the court to appoint agency to collect evidence in favor or in against any party to the litigation. The litigation and dismiss the petition, and the court observed that it amounts to collection of evidence. Learned counsel appearing for the petitioner submits that if the commissioner is appointed, that evidence will help the court to decide the dispute between the parties. and the court, without considering all this, had dismissed the petition. Next para, having heard the learned counsel, the petitioner produce the material on record. The suit is for declaration and injunction. When the party comes to the court, they have to prove their case by using cogent evidence. In this case, the evidence is not yet commenced. Now, at this stage, appointment of the commissioner is not necessary. When after the evidence is adduced by both the parties, and at that juncture, if it is relevant for appointment of the commissioner, the petitioner can always file an application, and in the facts and circumstances, if it is required, the court will consider in accordance with law. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to make this application at a later, after the evidence, at a later point of time, not at this stage. Yes.
Number 29, Avinash Malipat, please.
Suit filed by the Milord's defendant for partition and separate position, Milords. Suit filed by the defendant, Milords, the respondent for partition and separate position, Milords. Defendant number, yes, Milords. Defendant number 2, Milords, filed application for under section under order 16 calling for the summoning the document, Milords. Now, Milords, cross of PW 1, Milords, is pending, Milords. What is the very same property, Milord, earlier suit has been filed in the year 2007, Milord.
Continue after.
Kiran Kole?
Yeah, please, my lord.
Why you have to tap the screen? For him to- Yes,
Yeah, please, my lord. Serial number 30.
yes. Yes, please argue.
Submission Madi, Kiran.
My lord, the present petition is seeking issue for a writ of a certiorari to set aside the arbitral award, my lord. In this, there are four
What is
petitioners, my
wrong with
lord.
the award?
Pardon, my lord.
What is wrong with the award?
My lord, this is an ex-party arbitral award passed against the petitioners, my lord. The petitioners had not received the notices from the arbitrator, my lord. Still, the award has been passed unlawfully, my lord.
Let
To,
us see the award.
to exercise the page number 32 may kindly be perused, my lord. The petitioners had borrowed a mortgage loan from the respondent, my lord, and during the corona period, in spite of RBI giving various directions not to be strict on the liability loans, my lord, the respondents have arbitrarily unlawfully charged the petitioners with unlawful interest and other delayed payment charges, my lord, and they were not provided an suitable opportunity to represent themselves before the arbitrator, my lord, and an ex parte arbitral award was passed against the petitioners, against which now currently an execution petition is running before the honorable.
Come to paragraph number 2. Come to paragraph number 2 and read.
Please, my lord.
Yes. In the first paragraph, 3 lines above para 2. The claimant sent a request letter to the Council for Indian and International Arbitration.
Please, my lord. The petitioners were not residing
The
at that
claimant
addresses, my
entered
lord, but
appearance.
still they claim that the notices have been served, my lord.
The claimant entered appearance on 28/1/2023
The
and
claimant is the
filed the
company.
claim petition.
The respondent is the claimant over here,
Yes,
my lord.
next, respondents have failed to appear before the arbitration tribunal on hearing held on 28/1/2023.
Because the
However,
notices
in the
were not.
interest of natural justice, one more opportunity was granted to the respondent to appear before the tribunal and contest the case on 21/2/2023. The notice was sent through registered post at the last known address of the respondent on 8/2/2023 and which was received by the respondents.
This was the
What
issue
do you say?
actually. This was the issue actually over here, madam. The respondents, while availing the loan, were residing at that village, my lord. And after the corona, they had shifted themselves to a new place, my lord. At this place, they were not residing, my lord. Somebody else has accepted these notices, and it is deemed to be served by the arbitrator, my lord.
When you have taken the loan, is it not your duty to update your address with the bank?
My lord, they are illiterates, my lord, but still they have serviced the loan regularly, my lord. Due to the effect of the corona, they failed to service the loan in tandem, my lord. Now they came to know about this only when the execution was filed
We are
and the
not on the
execution notice was
point.
served to them in
We are not
person, my
on the
lord.
merits of the matter. We are not on the merits of the matter. Why you are not appeared is the question.
My lord, they were unaware of the arbitration proceedings initiated, my lord.
That the court and submit that an award is passed without issuing any notice to the petitioner. And now the execution is filed. It is a contention that earlier he was residing in the village, and later the petitioners are staying in Ballari. Residing where now?
Now they are residing
Where
at
are you residing now?
Hagari Bommanhalli only, my lord.
Agari Bomanahalli, Ballari. And it is the contention of the petitioner that it is not served on him. When he has obtained the loan from the bank, when there is an address, you ought to have notified the bank. However, it appears that the petitioner has notified has not notified the bank. The fact remains is, in view of this discrepancy, petitioner was not heard. In that view of the matter, there shall be stay of all further proceedings pursuant to the order, pursuant to the award dated 20th March 2023. Yes. Notice the respondent.
Petition note.
Please, madam.
Seal number 31.
I'm for the petitioner, my lord. Petitioner is a life convict, my lord. Completed 14 years. This writ petition filed by the petitioner seeking premature direction to the respondents to consider his case for premature release, my lord. Annexure B is the notification, my lord, page number 54. The relevant portion is, my lord, clause number 4A, page number 57, my lord. Clause 4A, page number 57, my lord, relevant portion. Clause 4A, male prisoners undergoing the sentence for life imprisonment shall be entitled to be considered for premature release after they have served total 14 years of imprisonment with remission, but only after completion of 10 years of actual imprisonment without remission.
Where are you reading?
My lord, page number 61 is custody. My lord, 57, page number 57, clause 4A, my lord. Male prisoners undergoing the sentence for life imprisonment shall be entitled to be considered for premature release after they have served total 14 years of imprisonment with remission, but only after completion of 10 years of actual imprisonment without remission. Page number 61, annexed custody certificate, my lord, annexure C.
Yes.
My lord, column number 9 is the actual sentence, my lord. He undergone, as on 12/8/25, he completed 11 year, 1 month, 13 days. And with remission, 10, column number 10 is the remission, 2 year, 11 month, 22 days. As on 12/8/25, he completed 14 year, 1 month. Till today, the jail authorities not released the petitioner so far, my lord. My lord, annexure F, similar circumstances, this honorable court granted parole till the final order passed by the government, my lord. Annexure F, my lord, page number 93.
Where is your representation to the respondents?
My lord, as per the direction issued by the honorable apex court, as per the guidelines, they have to serve, consider the case of the premature for premature release suo motu, my lord. There is no mechanism for.
Your request? Where is your request?
Madam, they will not receive any request, my lord. They will only consider, as per the guidelines, they will receive the, they will consider suo motu, my lord.
If they are not, no, you have come to the court. Can't you
Please,
ask them?
My lord, I
I'm
will produce
saying
one.
you have come to this court. Can't you ask
Please.
them that as per the guidelines, I'm entitled for this thing, please do it.
Madam, my information on January, they considered my case for advisory board, consider my case, not yet taken any decision, madam. But they have not provided any material.
Let them make a merits application to the authorities for consideration of his claim.
What is the procedure that?
Procedure, my lords, kindly see the ink page on 58. Lords, procedure to be adopted.
Rule 58.
Ink page on 58. Procedure to be, my lords, column number, my lords, 6. Ink page on 58, my lords. Immediately after, my lords, what my learned friend has read.
When it comes to the procedure to be adopted,
yes,
it doesn't say they shall make an application.
It
Wherever there is, they have
it is
completed
automatic.
14 years, it is for you people to do it.
It is automatic.
Then why they are not doing it?
And even his claim is that his application is already considered, but decision is not yet taken, what he has submitted.
No, there is no timeline for taking a decision.
Actually, it is in the, my lords, the rules, it is not there, my lords. But directions may be given to the respondent number 2, my lords, the committee. That is, my lords, Life Premature Release Committee, respondent number 2.
My lord, Annexure E, my lord, this honorable court in reported judgment in March 2023 issued certain guidelines. My lord, page number 75 of the order, Annexure E, my lord. The operative portion is, my lord, at page number 91. Direction number 3, my lord, in page number 91. It is made clear that the state government shall henceforth direct the second respondent or committee to meet once in 2 months in light of the direction issued by the Honorable Apex Court in the cases referred to in the course of the order. The next, my lord, page number 92, fourth direction. The direction shall be adhered from the 1st of April 2023. Fifth, my lord, the petitioner shall be considered for his release on general parole in accordance with law till the committee meets and consider his application for premature release. Even though they are not considering properly, right? On time basis, they are not considering, not conducting meeting.
SCGP, the ACA takes notice on behalf of the respondents 1 to 3. It is a contention of the petitioner that he has completed 14 years of imprisonment, and as per the circular issued and as per the judgments passed by the court, his case shall be considered for premature release, and this is an action to be taken by the respondent suo motu. For that, no application is required by the concern. Then the CDP shall get specific instructions. What is the procedure adopted by the respondents in case of these premature release of these life convicts who has completed 14 years of imprisonment? Why the petitioner is before this court? Why his case is not considered by the respondents? The material before this court reflects that he has already completed 14 years of imprisonment. What is the respondent shall specifically state what is the procedure and why they have not adhered to the same. Less is matter on 16th of February. By that time, the objection shall be on record, or else the court will be constrained to pass orders, and also taking note of the fact that the respondents are not diligent.
It's on which date? Date, my lords?
16.
Obliged.
Seal number 32. DJ Nayak.
For the petitioner. Yes, my lord, the petitioner has filed the complaint before the town police Bhatkal on 18/1/2016, 26, my lord. Thereafter, the
Directing the R2 and R5 to conduct investigation and arrest R7 for robbery case.
robbery case is filed against the accused. No investigation and Panchanama and
But what is to be done? When
nothing is conducted till today, my lord. The recovery has to be done, the weapons has to be recovered. Evidence.
This court will tell them, please arrest R7 for robbery case. Whether to arrest an accused or not, that is the prerogative of the police. If they are not doing, they are doing not doing.
305 is a cognizable and there is a provision to arrest without warrant, my lord.
But High Court will not look into all that. If you have anything, file a petition before the magistrate, asking them to do what they are supposed to do.
Article 21, my lord, the right to free, cease living alone.
Right to arrest the other person is.
Not the right, but the right to leave the, my lord.
Sorry, please come.
If the police is not given protection, my lord,
Petition is filed.
how can she live with?
Seeking the following prayers.
At least the investigation may be conducted under the provision, the SP.
The R7 is the husband of the petitioner, and they are living separately in the Bhatkal town. The petitioner filed an objection to the Salzar not to imitate the name of the respondent in the revenue record. On 16/1/10/2025, the petitioner filed complaint against R7. It is a case that the respondent number 4 and 5 not taken any action against R7 and not conducted the investigation. The R7 repeatedly attacking the petitioner. The incident has occurred in the premises of JFMC Bhatkal. The petitioner is living alone in her house. The R7 trying to dispossess her with gangsters, and the petitioner filed the complaint on 16/10/2025. and the FIR is registered against R7 and others. The police have registered the FIR and the further investigation is not conducted. R7 and others are coming up with an offense and also assaulted the petitioner in the day, and the petitioner is injured and taken treatment in the hospital. The police have not arrested R7 and not conducting inquiry and not conducting spot panchnama, and the weapons also not recovered from R7 and gangs. Hence, the petitioner is afraid to get out of the house and she is unable to lead her day-to-day life. According to the petitioner, it amounts to violation of the rights guaranteed under Article 21 of the Constitution. The petitioner has given the complaint. The complaint was registered on 16/10/2025. According to the petitioner, the R7 has to be arrested and they should conduct investigation and file a charge sheet. Now the FIR is registered on 16/10/2025 and another complaint is given on 18/1/2026. The respondents have to conduct the investigation and shall file the charge sheet. This court, now when the complaint itself is on 16/10/2025, the FIR is registered. The allegation of the petitioner that they are not conducted the investigation, they have not recovered the weapons, and this court is not inclined to interfere with any of this. And the police have their time to file the charge sheet by conducting a detailed inquiry. And as far as arresting the accused is concerned, if he is the causing the police for the purpose of investigation, if necessary, they will take the appropriate steps. This court under 226 cannot give any direction to the police. If the petitioner is aggrieved by any of the inaction on the part of the police, the petitioner can file a private complaint before the magistrate.
Take notice for R1 to R6.
R1?
R6. R1 to R6.
Note R1 to?
R6.
R6 SCDB takes notice. Yes, next.
Seal number 33, Hanuman Reddy Saukar.
Yes.
Petition by the dependent, the challenging the order, rejecting the return statement.
Rejecting the?
Return statement application, permission to file a return statement. In fact, it has.
Of which year? Suit is of which
It
year?
is 2024 minutes.
When did you enter appearance?
I appeared on 18/3/2025.
18?
3/2025. Thereafter, the very next day, it is 21/4 date was given. On 21/4/25, return statement was taken as nil. And thereafter, matter was posted for settlement. And trial court has applied the amendment provision. It came into force from 5/6/2025. Whereas the suit is filed much prior to that. That is on 15/11/24. Suit is filed. That is prospectively, it has to be.
As on 5/6/2025, you have not filed any return statement.
Yes, yes,
5/6/2025, as on the day provision has come into force.
Yes,
You
yes.
have not filed return statement.
Yes, yes.
So according to you, it will apply to the suits which are filed subsequent to that.
Suit is filed prior to amendment.
I'm saying, according to you, the amendment applies to the suits which are subsequent to the amendment, not to the prior to the amendment.
Yes, yes, because it is a prospective notice. It is 5/6/2025.
Please come and counsel the petitioner submits that the court has not permitted the petition to file the amendment in view of the amendment to the CPC, which is on 5/6/2025. In fact, the petitioner has entered appearance on 18/3/2025, and the suit is filed in the year 2024. And this amendment has no application to the facts of the case. Considering the same, there shall be stay. Notice to the respondent.
Stay. Issue notice.
Petition is permitted to take out hand summons and file a memo to that effect by 23rd of February, or else the stay granted by this court stands vacated.
Please.
It's 35,
35, 34?
34, yes.
Yuvraj Hiren?
Lord, Jilla Panchayat Belgaum has filed this petition, who is a judgment debtor number 2 in the execution proceedings. In a land acquisition matter, Lord, in order to enforce the LAC judgment, Lord, respond number 1 claimant filed a execution proceedings, wherein the petitioner herein, Lord, filed an application seeking for stay under order 21 to 26, read with 151 of CPC. Lord, the reason for seeking for a stay is that, Lord, facts of the case that subject properties have been acquired by the second respondent, land acquisition officer. Lord, thereafter, it was determined by the land acquisition officer at the first instance. Lord,
Who are you?
Lord,
Who are you?
I am the beneficiary, Lord. In the second round of litigation, Lord, I have been impleaded.
You have been?
Beneficiary, Lord. Jilla Panchayat. Instead of impleading Talaka Panchayat, Lord, I have been impleaded. Jilla Panchayat. In the second round, Lord. At the first round, the land acquisition officer determined the valuation of the property at the 19,000 per acre with the statutory benefits. Subsequently, they appeared and under protest, they have received the amount. Kindly see the annexure A. Thereafter, they preferred and referred the matter before the civil court. Civil court announced to the amount to the 2 lakh rupees 4,000 per acre, along with the statutory benefits. Thereafter, they filed an execution petition. It was referred to the Lok Adalat. Before the Lok Adalat, the entire amount has been received by the claimant. After receipt of the same, once again they preferred an appeal before the district court seeking for enhancement. That was dismissed. Against which they preferred a second appeal before the honorable court. Wherein, because by considering the point that under order 41 rule 27, the documents were not properly considered by the reference court. That's why remanded back for fresh consideration. After second, in the second round of litigation, Jilla Panchayat has been impleaded. Now, in the second round, it has been enhanced from the 2 lakh 4,000 to 4 lakh rupees per acre. In the earlier rounds, they received the compensation amount when it was determined by the land acquisition officer, and reference court has been enhanced up to 2 lakh 4,000 per acre. That was received by the compensation by the claimant. Now, we preferred an appeal challenging that land acquisition because I have been impleaded in the second round of litigation, and moreover, we are having a very good grounds that insofar as reference application itself is barred under section 18 class 2 of Land Acquisition Act, and the death person has been filed in a land acquisition, a reference application, and after completion of that land LAC, they have been deleted. These are all grounds, we are having in the appeals. And in the appeal, kindly see, the notice has been issued. Because it's preferred by the Jilla Panchayat by seeking permission as well as making arrangement for
How much delay?
342 days.
A year delay. Almost a year delay.
Please, notice has been issued on next date is 27 February. It is now it has been stands posted. In the meantime, in pursuance of the execution order, it has been delivered.
Supreme Court has no business to stay the proceedings.
My kind submission.
It is not what order you could not obtain before the appellate court in your IA. Executing court will not grant.
My only kind submission. We are not, we are abide by the conditions of a deposit of amount.
For 340 days without filing an appeal.
Please, because by obtaining the permission from the government as well as making arrangement for payment of a court fee is concerned, because 4 land acquisition cases connected. In those, my kind submission, if at all insisting for depositing of that amount in the EP claim, my lord, my appeal will be infractious because of a payment of a depositing of that amount.
Your remedy is, you have a remedy against the final
Yes, my
order.
lord.
You filed an appeal.
Yes, my lord.
The whole purpose of that IA in the appeal is to stay the further proceedings.
Yes, my lord.
Pursuant to the judgment and decree. Now, what you can't get it before the appellate court, you will go before the executing court and say, you stay the proceedings. Why should the executing court do it?
My lord, it was brought to the notice of the Honorable Execution Court also, my lord, insofar as, my lord, a notice has been issued.
The court has rightly done. So we shouldn't, because
My
your
lord,
remedy is before.
my lord, I am not seeking that, my lord, by, in the exceptional cases, my lord, if amount has been insisted for depositing, my lord, my appeal will be infractious.
Nobody stopped you filing, either it is government or any the private person. It is one and the same.
Please, my lord, my kind only submission is that, my lord, adjourn the matter since for consideration of that IA number 2 filed in the appeal, my lord. It is now, my lord, in the February 27.
Executing court to stop unless and until an order is passed by the appellate court. Where
My lord, merely, still it is not yet been disposed of by the Honorable Appellate Court.
If it is not, then you should have come before this court on that, not on this.
My lord, by reading the, my lord, Order 21 Rule 26 of CPC, my lord, by showing the sufficient cause means, my lord, here, we are not, my lord,
Sufficient cause is not this. It is not sufficient cause. Now, then there is no, if your argument has to be taken, nobody has to file an appeal. Nobody has to, have a stay in the appeal. They can straight away just file an appeal, keep quiet, go before the executing court and seek stay of the proceedings under so and so.
my lord, my kind submission only that, my lord, if at all directing the insisting for payment of that EP claim amount, my lord, the appeal would be infractious. Otherwise, my lord, may be permitted to deposit the same before the EP court also, my lord, but subject to deposit.
Please make all these submissions before the appellate court. If the appellate court doesn't understand what you're submitting, then you come to the court. But EP court, there is no, we will not ask the EP to be stalled. Please.
Lord, because my kind submission is only that, my lord.
I will record, agreed with the orders
Please.
passed. I number 2 in AP number 25 of 2025, dated 21st January 2026. The judgment debtor is before this court. He has filed the application, the IA number 2, under Order 21, Rule 26, read with Section 151 CPC, seeking stay of all for the execution proceedings till disposal of the miscellaneous appeal number 58 of 2025, pending on the file of the First Additional District and Session Judge, Belgavi, which is filed challenging the judgment and award passed in LAC number 51 of 2009, dated 22/10/2024. That came to be dismissed by order impugned, whereby the court has observed that in the present case, appeal is admittedly filed with a delay and the appellate has only issued notice on the application for condonation of delay, and on the stay application, no interim order staying execution has been granted. Therefore, the decree holder's right to proceed with execution remains unaffected. The contention of the JDR 2 that the execution should be stayed to avoid hardship cannot be accepted in the absence of a statutory provision or an order of stay from the competent appellate court. The executing court cannot sit in appeal over the decree, nor can it grant a stay when the appeal is already filed and is pending consideration. And the court had considered the judgment of the Kerala High Court in Shamala versus Tapodanan 2020 SCC online Kerala 8401. Accordingly, the court had dismissed the petition. When counsel appearing for the judgment debtor submits that the judgment debtor has filed the appeal against the judgment and decree with a delay of 342 days. The court had ordered notice and the same is the IA seeking stay is pending consultation. Unless and until the stay is granted by this court, it would cause lot of hardship to the petitioner judgment debtor. It is submitted that under Order 21, Rule 26, if a reasonable cause is shown, the executing court has got the power to stay the execution. It is submitted that the executing court has failed to exercise the jurisdiction vested in it unless the execution proceedings are stayed, the petitioner would be put to lot of hardship. Thanks for having heard the learned counsel for the petitioner peruse the material on record. When a judgment and decree dated 22/10/2024 is passed, an judgment and award was passed in LAC number 51 of 2009, dated 22/10/2024. The judgment debtor, who is a beneficiary in the land acquisition proceedings, ought to have preferred an appeal. For the reasons best known to them, an appeal is filed with a delay of 42 days.
42 days delay.
42 days. The court has rightly issued notice and the IA first day is pending. The submission of the learned counsel that under order 20, under rule 26, if the reasonable cause is shown, the court can stay the proceedings. This cannot be termed as a reasonable cause when the party, as per the framework under the Civil Procedure Code, has to prefer an appeal against an order which is agreed, and before the appellate court there is a provision to seek stay of the further proceedings. The petitioner who could not be successful before the appellate court for the reason of delay now cannot insist the executing court to stay the proceedings till the application is decided by the appellate court. The executing court had rightly discussed and rightly observed that it cannot grant a stay and cannot and the petition unless and until an order is passed in the appeal. This court do not find any reasons to interfere. The court had rightly considered and passed order accordingly dismissed.
It is also my ground that if insisting for depositing of that amount, my appeal would be rendered infectious.
It is submitted that if he pays any amount, his appeal would become infectious.
I take notice for R2, my lords.
So the AGA takes notice for R2.
Please.
Yes, next.
Serial number 37 is also similar one.
Same.
37, same.
Yes, 37
Please.
also same order.
Please.
Yes, 35.
Bill number 35. Vinayak Megundi.
That's for the petitioners. I've filed an application seeking permission to file the return statement. Seeking permission to file the return statement. I'm the bona fide purchaser, my lords. Entered
Which year?
25 minutes.
Hmm.
Entered appearance on 1/8/2020,
It's
2025.
after the amendment. That is after the amendment.
Please. That's I approach the only.
No, is there any discretion vested with the court after the amendment?
No, my lords.
Then,
Only on humanitarian grounds I'm approaching. Only I'm the bona fide purchaser, my lords.
whatever it is,
Please.
if there is discretion, we will
Please.
ask them to exercise it.
Please, ma'am.
If there is no discretion, what we can do? What the court can do?
Please.
Please come. The present petition is filed. Writ petition is filed, agreed with the orders passed in. IA number 1, invoice number 316 of 2025 dated 4/7/2025. The respondent herein has filed a suit for partition. No, this is not IA number 3. It is an application that's filed under Order 8, Rule 1 CPC to condone the delay and seek permission of the court to file the written statement. The court had dismissed the same by order impugned dated 3/1/2026. Earlier that corrected, 3/1/2026. The court has observed that the defendant number 3 has appeared before the court on 1/8/2025. The advocate for defendant filed application seeking permission of the court to file the written statement on 3/1/2026. The court observed that the plain reading of Order 8, Rule 1 of the amended CPC, when the defendant fails to file the written statement within a period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for reasons to be recorded in writing, and on payment of such cost as the court deem fit, but which shall not be later than 120 days from the date of service of summons, and on expiry of 120 days from the date of service of summons, the defendant shall forfeit the defendant's right shall be forfeited to file the written statement, and the court shall not allow the written statement to be taken on record. The court observed that the amended proviso to Order 8, Rule 1 is not discretionary, but it is mandatory. The court cannot permit to file the written statement in exercising the inherent powers after 120 days from service of summons to defendant. It is observed that the discretionary power of the court after 120 days is taken away by proviso to Order 8, Rule 1 of CPC. It is observed that when the law mandates the same, the court should not allow the defendants to file the written statement. When counsel appearing for the petitioner submits the petitioner, unless the written statement is filed, it would cause lot of hardship to the petitioner, defendant, and the litigation cannot be taken to any logical end. Court ought to have considered and ought to have condoned the delay. Next, by having heard the learned counsel for the petitioner, perused by the material on record. The amended Order 8, Rule 1, that please extract. This amendment has come into force on 5/6/2025. After the amendment, no discretion is left with the court to condone the delay, as the amended provision says that the court shall not allow the written statement to be taken on record. The use of the word shall makes it very clear, and the court has no such discretion to allow the written statement. In that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed.
Seal number 36, Patil Basavaraj, Naganagowda.
My lord, appearing for the petition, my lord. The petitioner is the defendant number 1, my lord, before the trial court, and my lord, and is unable to file the written statement on time, my lord. Same, my lord. And the suit is for 24 years. Suit is for last year, 24, my lord.
No, but what we do with this amendment? Now, if it is discretion that we can understand, it's a 24 suit you are going to file.
Yes.
Now, once the time is lapsed in view of the amendment, you are not
But
permitted.
we filed the IA also, my lord, along with the written statement. That IA was rejected, my lord. And
That's what I'm saying.
yes, my lord. And plaintiff.
You tell the court if what is wrong, if you're able to convince the court that such an order can't be passed, I'll consider it. See, the petition is filed. Where is the order?
My lord, page number 43, my lord.
43. The present petition is filed. Exhibit order.
And one more submission, my lord. Plaintiffs have submitted no objection to allow the IA, my lord.
No, it is not. It's not for the plaintiff or for the court. They have to go by what the law says.
Yes,
It is that it shall not.
Yes.
Court shall not.
Yes.
The present petition is filed by the petitioner defendant, agreed by the order dated 10/10/2025, whereby the court has refused to receive the written statement. The order impugned. The court has observed that the defendant number 1 and 3 have put in appearance through their counsel on 31/1/2025, and the decision taken has not filed on 1/3. Now the defendant. Now you have to say whether it is prospective or retrospective.
Prospective.
It's
prospective.
The defendant number 1 and 3 have filed the IA on 26/9/2025. And the court has dismissed the same as there is a delay of 8 months. Land counsel for the petitioner submits that the amendment to the order, the amendment came into effect on 5/6/2025, and the suit is much prior to the same. And the amendment has no application to the facts of the case, and the court ought to have considered it. Considering the submission, they shall be stay of all further proceedings. The petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court, and shall file a memo to that effect by 23rd, or else the stay granted by this court stands vacated. Yes.
Appeal number 38, Prakashas Gudi Hindina.
Please, my lord. The present petitioner herein has filed the complaint before the respondent, my lord, and stated that certain persons are the beaten the complaint petitioner with the stones and iron rod, my lord, and seeking a registration of the FIR, my lord. Before the respondent, he has filed the complaint, but respondent has not considered the said complaint, my lord. Hence, the petitioner has submitted the said complaint before the higher authorities, my lord, but they are also not considered the same.
When was your representation to the higher authorities?
My lord. Yeah. Annexure F, my lord.
Page number, the date.
44, my lord. 44, my lord. Sorry, my lord. My lord, same date, my lord. Annexure A1, my lord, page number 13, my lord. I'm submitted the said representation to the DISP on 28/8/2025.
Whom you have given?
My lord, I'm the petitioner, my lord. I'm given to the DISP, my lord. And first one is given to the PS.
Come to the cause title.
Please, my lord.
Come to the cause title.
Please, my lord. Yes.
Which respondent you have given?
SP, PSI, and police sub-inspector, my lord.
Police inspector is the one who has registered the case. What is that police inspector again? Why you have made sub-inspector, police inspector? You have given a complaint to 2 and 1.
My lord, I am given a complaint to the respondent number 1, 2, 3, my lord.
Who has to register the complaint?
The local jurisdiction respondent number 3, my lord, police sub-inspector.
It is the case of the petitioner. The present petition is filed saying the following prayer. It is a case of the petitioner that he has given a complaint to the police on 28/8/2025. And so far the police have not registered the crime. In this regard, he has already given representations to 1 and 2 about the inaction on the part of the third respondent. Even the first and second respondents have also not considered the same, and they have not filed. They have not taken any action. It is submitted that when a complaint is given to the police, they have to act in accordance with law. Questioning their inaction is before this court. Whenever a complaint is given, if the respondents are not entertaining, if the concern is not entertaining the complaint, the remedy available to the party is either to give a complaint to the higher authorities or to file a private complaint before the magistrate. In this case, the petitioner has already given complaint to the higher authorities, that is 1 and 2. It appears that the respondents also have not acted on the representation. There HEA submits that he'll get instructions in this regard.
On submission.
Having heard so and so. Considering the fact that when a complaint is given to the police, they are bound to act in accordance with law. If it makes out an offense, they will register the FIR. If not, they will file a P report. But either of it, they have to act, and they cannot keep quiet. And when a complaint is given to 1 and 2, what action they have taken is not forthcoming. Hence, in these circumstances, this court is passing the following order. The writ petition is disposed of, directing the respondents to consider the complaint of the petitioner dated 28/8/2025 in accordance with law within a period of 2 weeks from the date of receipt of the copy of the order.
Takes notice for R1 to R3. R1 to notice.
To R3, AGA takes notice.
Case number 39.
Public.
Arjun Third Party.
Lordship, petitioner in challenging not the order rejecting the application filed for implement in the execution proceedings, my lord. Lordship, the petitioner and respondents are the lord, the relatives, my lord. The respondent number 1 is the wife of petitioner, and 2 to 4 are the my lord, the daughters of petitioner's brother. Lordship, initially respondent number 3 here, who is petitioner brother's daughter, filed suit against the present petitioner and other family members, seeking declaration that she is the owner of the suit property. That came to him, Lord, dismissed for non-prosecution. Thereafter, my lord, I have filed a suit for declaring for easement rights since they were disturbing for road, etc. In that proceedings, my lord, the status quo with respect to my lord, the property is already granted. Further, my lord, another suit is filed for partition by the one of the sister of the my lord, the petitioner. There are total 3 brothers.
What is the objection you have filed?
Lordship, in spite of all pending all these proceedings, my lord, suit for partition is also pending. There is no partition. The respondent number 1 here in filed him, Lord, the suit for specific performance against 2 to 4, and the suit came to him, Lord, the compromise. Behind suppressing all those, they are parties to him, Lord, the other proceedings. 2 suits, my lord, and 1 is dismissed.
You have questioned it.
Lordship, upon coming to know, Lord, they file immediately file within 1 month, my lord, they filed the execution petition. I have filed implementing application in the, my lord, the execution proceedings. That we are in possession. There is no partition in the family.
When they have obtained in a compromise decree, are you not supposed to question that compromise decree?
No, the compromise is suit for specific performance is filed, and they themselves, lordship, on
Decree, it is a joint family property, it's a collusive decree. That is what you are supposed to say. Without doing it, you go and ask the executing court to stay. Why will it stay?
Lordship, I am seeking only, my lord, implement in the, my lord, the proceedings, because for executing court, my lord, who are in possession, property is not divided. In order to bring,
You have filed a petition as an obstructor.
as implementing application is filed, order 1 rule 10 is filed. To bring on record, my lord, that 2 proceedings are pending.
Execution proceedings, if you are in possession of the property, and if you are questioning, if that's the case, you will file an application under order 21 rule 97 or order 1 rule 10.
As an obstructor, my lord, they has to file, my lord.
How can order 1 rule 10 be maintainable?
And now, after rejection of this my application, my lord, the further court commissioner is appointed to execute the sale deed, my lord. The persons, my lord, how it is a collusive decree, my lord.
Now the court's advice is you have to go before, you have to question that collusive decree, not execution petition. You will not get anything. Say your ground is something else.
Actually, the executing court dismisses holding that in a comprehensive suit, you can hesitate your rights. How?
No, even that also, you say that it's a joint family property. Both of them have filed a collusive suit and obtained. So unless and until that is decided, the suit for partition where all of you are parties, question of executing the sale deed will not arise.
And in the partition suit, my lord, there is also temporary injunction order not to alienate this property against the
But I'm saying
respondents herein.
But that you can't agitate in an execution case. What do you want?
I will seek next week, I will seek instruction, my lord.
Notice to the respondent.
Notice.
Please.
Petition is permitted to take out hand summons.
Now, my lord, the sale deed is if executed, again it will.
Number 40. Number 40. Upon Nagaraj.
Recreation club matter, lordship, seeking mandamus, lordship.
My instructions are that, my lords, they are not interfering.
The writ petition is filed in the following frame. The petitioner association it's a case that the petitioner is duly registered under the Karnataka Societies Registration Act, and they're conducting games like cricket, kabaddi, karate, chess, caroms, and also conducting indoor and outdoor skill games and other activities. It is submitted, it is stated that the authorities are also insisting them to take the license under the Karnataka Police Act. In the light of the judgment of this court in Rama Recreation Association versus Commissioner of Police, reported in ILR 1993 Karnataka 3357, association cannot be compelled to obtain a license under the Police Act. It is a grievance of the petitioner that while the petitioners are conducting regular activities, the respondents 2 and 3, 6 or 2 to 6 are interfering and insisting upon the petitioner for obtaining a license. He has brought to the notice of the court the judgments of this court in that regard. It is a grievance that the respondents, in spite of the same, are regularly interfering. Learned AGA representing respondents
R1 to
1 to
R6.
6 submits that they, as per his instructions, they are not interfering. It is submitted that as per the judgment passed by this court, as per the guidelines issued by this court in WP number 101879 of 2024, the police have the liberty to inspect the premises to find out whether illegal activities are happening, if any illegal activities are taking place. Other than that, they are not interfering. Next, having heard so and so, according to the petitioner, there is interference, and according to the respondent, there is no interference. As rightly submitted by the learned AGA, as per the order that the petitioner is relying on, WP number 101879 of 2024, police have every authority to inspect the premises. In that view of the matter, this court is passing the following order. The WP number, the petition is allowed by directing the respondents not to interfere in the day-to-day business of in day-to-day activities of the petitioner club without following due process of law. This order will not preclude number 2. This order will not preclude the respondent from conducting any inspection any inspection in accordance with law.
Please, please.
Seal number 41, KL Part.
Petitioner is a tenderer who was awarded work of repair of the road, and he has completed the entire tender work in the year 2022 itself. Completion certificate is issued, final bills are paid. A complaint is filed saying that the road is constructed with substandard quality. Lokayukta sends a team of experts to inspect the road. In 2024, they make an inspection, and they say that one component out of all the components, one component there is lesser quantity. Therefore, the entire damage is estimated to be 80 lakhs odd. And they say that action has to be taken against erring officials. Now, in the guise of that, my lords, they want to recover from me the entire amount which is due in other contract works. Impugned endorsement, if your lordships could kindly see impugned order, which is annexure J. There they say that there are other works pending. From those bills, this 86 lakhs has to be deducted. They don't resort to judicial proceedings, no quantification, nothing. Lokayukta says take action against erring officials.
Yes. Were they heard before the Lokayukta?
They are not heard.
Then how can such an order be passed by the Lokayukta?
I'll take instructions. I'll take notice for R1 and
That order?
Sorry, my lord.
Where is that order?
Annexure J, page 82.
80?
82. I'm sorry, 87. Last para.
I'll pass an order. Please file a translated copy of this. When?
Please.
Day after.
Day after tomorrow. Yes.
The petitioner shall file the translated copy of annexure J.
Obliged.
6. Seal number 42. Basuraj Matpati.
Seal number 42, I appear for the petitioner, my lords. Prayer is at page number 13. I'm challenging the tender notifications passed by respondent number 2, my lords. Respondent number 2 has passed 6 tender notifications for the procurement of certain goods. My lords, the petitioner's grievance is that the goods that are sought to be supplied are so varied and disconnected to one another, my lords, that it has the effect of reducing the participation of the playing field thereby hindering the tendering process itself. Lordship, may I please see, my lords, page
What
number
is-
70.
Let us see, what are your grounds?
My lords, my grounds
No,
are.
I think this tender process, it is very difficult for the government to float any tender. What I
My lords,
found in
there
this
is-
bench is every tender that is floated is questioned
My lords, there is certainly
on some
discretion.
ground or the other.
My lords, there's certainly some discretion, but the discretion has to be discharged
Let's see,
reasonably.
let's
My lords,
see.
that is my.
Let us see from your petition.
Page number 17, my writ petition, my lords, my grounds are at page number 9, where I have challenged
Yes.
it. See, para 17, my lords, the tender is for supply of various goods which are diverse, varied, and non-homogeneous in nature, and therefore the supply of which can only be made by a few entities and not by a large section of the market who are operating sector-wise or even category-wise. The terms of the tender restricting participation of a large number of players in the market and restrict their participation in the tender, thereby negating the objector of the tenders in the first place, whose ultimate aim is to foster greater.
The person who is floating the tender, he knows about his requirements.
Please, my
No,
lords,
he
knows.
will not have the terms which will suit your convenience.
No, my lords, my only submission is, my lords, let the tender be called for category-wise, my lords, because what happens is, here they've called for furnitures, printers, safety materials, and even different kinds of ropes, my lords, which no single entity can put. Please see, my lords, page number 70. I'll just make this clear, my lords.
No, if you are not able to do it, don't participate.
No, my lords.
No, it is not, all these are not for the benefit of you. It is their
Please, my lords,
convenience. What
they
is
restrict
wrong?
the scope of the
If they
tender.
want to have it, huh?
They restrict the scope of the participating entities, my lords. Only a certain people can participate. For example, my lords, if I participate.
You take notice to whom?
For R1, my lords.
First and
R2, my lords.
second also.
Second is my lords.
First respondent, AGI takes notice to
For R1, my lords, committee appears for R2.
so and so is directed to take notice on behalf of second respondent.
Please.
Then counsel for the petition is out the copy of the writ petition on the council.
Yes,
This is matter on 18 by the time the respondent shall get specific instructions. Yes, 43.
What is matter? Seal number 43, case party.
My lordship, appearing for the appellant, my lordship, the impugned order has been passed by this honorable court on 27/6/25, my lordship, subject to condition of deposit of 50% of the award amount before this honorable court. The appellants have deposited 50% of amount, which is 4,58,440 before the reference court, my lordship.
Permitted to withdraw the amount. For respondent number 3, I filed my I.
My lordship, through oversight and by mistake, they have deposited in the reference court. So hence kindly,
That will be the direction will be given.
my lordship, for that I'm filing memo for acknowledgement.
This court,
My lordship, and one more humble submission.
he wants to withdraw the money.
50% will be, the only 50% is deposited.
7/6/2025. An order was passed directing them to deposit the amount, 50% amount before this court.
My lordship, humble submission and 33 days of delays.
That we will see later. Along with to deposit 50% of the amount before this court. It is submitted that due to oversight, they have deposited it before the
Reference court.
before the
Reference court.
reference court. And the acknowledgement is placed before the court. IA number 1/2026 is filed.
My lordship will file the objections 10 days time may be given.
Withdrawal.
What objections you will file?
We will-
Withdrawal in
Okay,
objection.
sorry, my lordship.
IA number 1/2026 is filed, seeking withdrawal of the amount filed by the advocate for, withdrawal is filed by the respondent
Number
number 3, who are the claimants. The claimants are at liberty to withdraw the amount.
And stay, stay.
Stay is already granted.
Yes, ma'am.
It is not a limited stay. Stay on the condition of depositing the
Conditional stage.
amount. Compared with the condition.
After the 4 weeks, he can deposit it.
Yes.
Seal number 44, Sadiq Jan Gudwala.
Petitioner, sir.
Dinesh M. Kulkarni.
And for petitioner, the counsel for petitioner is going on federal, sir. His relation died on yesterday. Till next week, any date, Lordship.
Monday it is not possible for the court. Let's just matter on Thursday. Yes.
Thursday,
45.
Tuesday, Lordship, please.
Thursday. Yes, 45.
12. Seal number 45. Mantesh R. Patil.
Memo for withdrawal.
I filed application memo for withdrawal of the writ petition.
Give the proceeding sheet.
Sorry, ma'am.
You paid the money?
My lord, bank authorities have, my lord, informed me that if a writ petition is withdrawn by me, my lord, they will give me, my
I'm asking, have you complied with the order dated 24/2/2025?
no, my lord, because,
You were having stay without paying the amount from there to now.
no, my lord, bank authorities, my lord, given us one-time
Uh,
settlement amount, my lord. That is the reason, my lord, I have
Memo
not
is filed.
deposited the amount, my lord.
Stating that the respondent bank has orally assured for settlement under OTS as the petition wants to withdraw the writ petition. Dismissed as withdrawn.
Please.
Yes, 46.
Seal number 46. Harshvardhan M. Patil.
For the petitioner, my lord.
Have you filed the memo?
I will file the memo, my lord.
Huh?
Today I will file the memo, my lord.
Yes, the petition shall file the memo. Yes. Next, 47.
We have paid the PF, my lord. Notice may.
Huh?
Notice may kindly be issued, my lord. We have paid the PF.
No, you already taken hand summons. Then it's sufficient.
The date may
It
be.
is submitted that they've already taken out hand summons on the council, appearing before the trial court. And they will file a memo to that effect. This is matter on 23rd.
23rd.
Is 47.
Seal number 47. Nilendra D. Gunde.
Petitioner. Senior counsel Jay Kumar is in. No, so for a service is concerned, not service is
47?
completed. A memo is filed to the effect that not some memo is filed to the effect that not the summons are served not the council appearing not for respond number 8 and 9.
That they serve the copies of the petition on R8 and on R9. Accordingly, notice to 8 and 9 is held sufficient.
Senior is appearing in that. Jay Kumar Patil.
ಡಬಲ್ ಲಾಗಿನ್ ಆಗಿದೆ.
Yes.
Sir.
After the issue of the calendar of events, on the last date of filing of nomination was over, on that day, 2 persons file a petition purported to be under section 70 of the Cooperative Societies Act, saying voter list is not properly prepared. On that, an order is passed staying the entire election.
There is order.
Lord,
Please, my lord, it would be order annexure E.
page
Sorry, my
22.
lord, whether they have furnished the translation at all.
What this order says?
This order says that 2 persons have filed the petition under section 70, saying that procedure for preparation of the voter list is not properly followed. On that ground, an ex parte order of staying the election of, in midway through. This order is passed on 4/10/25, on which date actually the last date for filing nomination was over. Entire election is
Not this is a case, my lord, there is the society in violation of the provisions of 13D2A, my lord, the election process has been started. So therefore, my lord, the dispute has been raised
by the member before the competent register. And Register of Cooperative Society, taking note of the provisions of 13D2A and provisions of the judgment of this honorable court, has granted the
Yes.
13D2A rule.
He has objected under 70, it seems.
Yes, yes, madam. The other members of the society,
Let's see.
Please.
There is that section, what it says.
13D2A, madam. I request this honorable court kindly take the rules, madam. Karnataka Cooperative Society.
Rule.
Rule 13D2A.
Yes.
Which says, madam, the 13D provides for preparation of the voter list. There is an amendment to the section, and it by 2020 amendment 2A was been added. This 2A, the section 2A mandates, madam, the election officer shall take the steps to publication of voter list who are not eligible to vote in the following manners, namely, for publication of the, kindly mark this, madam,
Can I do reading?
the 13D2A, madam, rule 13D,
13.
D, capital D, subclass 2, subclass A, capital A. This was been added by way of amendment, madam, 2022, to implement the mandate of rule 20, subclass 4 and subclass 5, madam. This rule has been added, which says, madam, for the publication of draft ineligible electoral list, the chief executive officer of every cooperative society shall prepare a notice in respect of members not attending 3 out of last 5 annual general body meetings and members not furnishing such minimum service facility for years such as been bylaws of the 3 consecutive meeting. The rule act mandates, my lord, one should attend the 3 general body. Compulsorily, the member should attend 2 general body meeting and they should avail the minimum service. Otherwise, they will entitled for disqualification. To regulate that procedure, my lord, 2020 procedure has been added. Before 6 months only, they bound to give the notice to the members, saying that why your name has been included under this list. Kindly give the objection. Without following that procedure, my lord,
Months or 3 months?
before 6 months. And next, my lord, the chief executive cooperative class 2, in ineligible members 15 days prior to 6 months, that is the second, my lord. The first one is to be published before 6 months, my lord.
Yes.
So this has not been done. So therefore, my lord, the members have raised the dispute. Kindly take the section 70. Even before the disputes under section 70 cover the broader aspect, which cover all the aspect, management, any affairs of the relating to the cooperative society covered under the section 70. So therefore, some of the members have raised the dispute before the authority. Considering the violations of 13D2, interim order has been granted. Suppose if the interim order is not granted, that is amount to continuing the illegality should be continued. So therefore, the authority has been granted the interim order stay. Let there be direction to the authority to dispose of this case within a period of 1 month and over the election. See, already election process is interrupted. So he has entertained the election petition, the dispute under section 70. Let there be direction to the authority, my lord. Since there is a direction from this honorable court, the proceedings before the register is also been stayed by this honorable court. Therefore, the register has not proceeded with the matter.
Yes, yes, Mr. Senior.
And there is a judgment, my lord, which says, my lord, the 13D is bound to be followed. That is the judgment of this honorable court, my lord. It has been clearly demonstrated. Held that the sorry, my lord. Two judgments, my lord, which says 13D is mandatorily followed. Well, paragraph 47. Paragraph page 47, madam.
Yes.
We are also conscious of the provisions of rules regulating the preparation for conducting the election in a cooperative society. Do merit recasting, there would be clarity to whether duty needs to be performed by of whom and the electoral process. The new board has to be constituted so and so, so and so. Next one. The provisions of Rule 13D cast the duty upon CEO to cast a preparation of public voter list. Final eligibility list. 13D4 duty cast upon every society to furnish the information required by so and so, so and so, so and so. Then, my lord, it has all been that in respect of 13, and this honorable court, my lord, this specifically referring this sections, my lord, 13 to paragraph page 19, my lord, referring the 13 due to A. Page 19, my lord, they refer the paragraph 13 due to A provisions and hold that, my lord, there is the directions of learned single judge to follow the 13 due to A. Rule 32 is mandatory. And subsequently, my lord, one more judgment which says following this judgment, even that has to be by not by service, it should be by registered post. The same judgment, my lord, the another judgment of coordinate bench, which says, my lord, 13 due to mandate, 13 due to A is mandatorily to be followed. It is not officer who has interrupted the election, my lord. It is by way of the process known to the law under section 70, dispute has been raised. The dispute is pending before the authority. Now, let there be the another judgment, my lord, which says 13 due to A, my lord, followed the same judgment. However, only distinguishing factor in this case is that, my lord, the court said it should be by way of the registered post. Well, I request this honorable court, my lord, paragraph 21. Page 21, paragraph 11, the judgment which I have just now read out has been followed. Then, my lord, paragraph page 32, the coordinate bench clearly holds that rule 13(2) has to be followed in letter and spirit. Though the consequences of not following is not involved in the rules, the annexes for the mandate that rule mode a service of particular method, said method cannot be given go by. It is title of the prescribed method of the execution of provisions of law. It should be executed in that manner known to the law. The circumstances of exhibit page 32 minute cannot be override or dilute the mandate of the law. So therefore, my lord, my only request is let there be direction to the registrar to dispose of within 15. Let them, my learned friend, appear before the registrar, my lord. And let the registrar take a decision.
Yes, Mr. Sineva.
Please, your lordship may kindly see annexure A, calendar of events. It is issued on 24/9/2025.
Page 11. Page 11.
Annexure A, page 11. The last date for filing the nomination was 4/10/2025.
Did you read that?
Notes, page 11. Notes in that notes. The last date is not 4/11. That is the second one, Milords. That was the day, Milords, on which the writ was also.
Yes.
4/10/2025, calendar of events, nominations were already filed. At that stage, a writ petition, a dispute under section 70 is filed. Your lordship may kindly see section 70, my lord. Section 70, subsection 2. Section 70 provides for subsection 1 provides for notwithstanding anything contained in any law for the time being in force, if any dispute touching the constitution, management, or the business of cooperative society arises. Subsection 2, for the purpose of subsection 1, the following shall be deemed to be disputes touching the constitution, management, or business of a cooperative society. In that, kindly see C. Any dispute arising in connection with the election of a president, vice president, any office bearer, or member of the board of society, a dispute can be filed. 70 subsection A, limitation.
I've seen. Yes.
No dispute under section 70 shall be entertained unless it is referred to registrar within 6 years from the date of cause of action. Then, provided that a dispute relating to the election of a member of president, vice president, or other office bearer shall be referred to the registrar within 30 days from the date of declaration of the result of election. It's only after the election that dispute can be filed. Even in writ petitions, court very rarely says total election being stayed.
No, like when there is a clear irregularity and when they are not as per the provisions of the act, when a particular act is not done, why should one wait till the election completes?
Of course, my lord, even under that melody, your lordships may kindly see, right from Ponnuswamy case, it's being held. It's only after the election that these things would start, particularly when calendar of events is issued and partly the calendar of events has moved to the stage of filing of nomination. Even under 226, that is normally followed unless something is made out. I don't say that it's a ground cannot be taken or anything, but as regards the matter pertaining to election, once the calendar of events is issued, the deputy registrar staying it at the instance of 2 members. It is not their case that those 2 members are not allowed to vote. A general dispute is filed saying 13D2 is not followed.
Their case also, my lord,
What do you say?
Their case is in their meeting, delegates
There
are not properly
is a
elected.
judgment of this honorable court, my lord, which says even 70 is available before election. If the illegal, assume for the sake of argument, my lord, if there is no provisions, my lord, should we wait for committing of illegality and should they complete the election process? I cannot approach directly before this honorable court, saying that there is a illegality that stop the election process. That is a restrictive interpretation of section 70. This honorable court already holds that, my lord. I will give you some judgment. We have it on next week, which clearly says, my lord, even before the election process has started, it is a dispute touching the management of the affairs of the society. Any dispute, my lord, section 70 was broadly interpreted. Otherwise, my lord, it is amount to continuing the illegality. So therefore, my lord, my only request is, let us, these are the disputed question of facts, my lord. Let there be direction to the authority.
This is Sparta next week.
Please.
Interim order needs to be extended.
Interim order granted is extended.
Next.
At the request of DAG, this is Sparta next week.
Any date may be.
It will come on 19.
Please.
Yes.
Bill number 48. Deepak Magnu.
Petitioner filed an application under order 21 Rule 58 of CPC, my lord, which came to be rejected by
All the respondents are served.
Respond number 1 has been served. Respond number 2 and 3 address has been found incorrect, and respond number 2 and 3. And respond number 5
there
is
was a
dead.
direction to take out hand summons.
Please, my lord.
There was a direction to take out hand summons.
There was a direction, my lord. Already a contesting respondent has been served. Now, respond number 2, 3 address is incorrect. I'll verify and take the fresh steps.
No. Hand summons to the, this is a tender matter.
This is recovery proceedings, my lord.
48. CFA matter. Yes.
As far as respond number 6, I have paid a deficit court fee, my lord, process fee. Regarding the bringing of the LRs of respond number 5 and ascertaining address of 2 and 3, I need a week's time. In the meantime, the court sale has been ordered, my lord. Kindly stay. I am asking for the interim pay. At page number 30, there is an order of sale, my lord. In page number 30. And there is a suit for partition. My mother and brother are the surety to the principal borrower. Now, under this recovery proceeding, our property has been put to sale, which is worth more than crore rupees, and recovery proceedings is of rupees 7 lakh at the interest of 24% on the principal amount.
You have to notice not issued to RCs for want of.
I paid, my lord. Today, I paid the.
We submitted that. The needful is done. This after service of notice.
My lord, at least interim order, my lord. At least a date may be fixed, my lord.
This is once this one on a notice is served, it will come.
Bill number 49.
Hand notice, my lord.
Now,
I am
Srikanth.
permitted to take the hand notice, my lord, to serve the by hand to the other respondent.
But in addition to that, petition is also permitted to take out application from. Yes.
Seal number 49. Now, Srikanth.
Petitioner has served the writ petition copies personally, my lord, for respond number 2 and 3. Undertake to appear for respond number 2 and 3, my lord. My counsel is represented, Mr. M.R.C. Ravi is online, my lord, for respondent. He has been muted. Mute, my lord. He has muted. M.R.C. Prashant BR.
This is a tender matter.
Unmute ಮಾಡ್ಕೊಳ್ಳಿ.
This matter, my lords, is pertaining to the
Lord,
calling for the tender, my lords, by the modifying the conditions.
Respondents 2 and 3. Well, I pray for a short adjournment, my lord, to file my objections.
My lords, already 3 adjournments, my lords, were already granted to them.
Well, I
In
received
fact,
the
my lords,
copy only 2 days back.
On the other
A
occasion,
short adjournment. Kindly have it next week.
on the other occasions, my lords,
Matter on 19th.
lords, in the meantime, my lords, they are proceeding with the tender proceed.
Let them not finalize the tender.
Senior is appearing, my lords.
Yes.
There is
A
already
little more, little early date, my lords, because, my lords,
A
little
short
early
date will
date,
be
my lords.
given because the tender will be
Because
finalized.
already 3 adjournments, my lords, they have taken. On the last
And
occasion also, my lord has warned them, my lords, not to.
14,
Seal number 50. Girish Yadwad. Shashidhar Havargi.
Yes. R 14 to 15 notice.
Senior counsel is on VC, my lords. Senior is on VC.
Yeah. Jay Kumar. Jay Kumar.
Please,
Bill number 50.
your lordship may kindly see, in this matter, again a dispute under section 70 filed and election is stayed. Your lordship may kindly turn to page 26.
By the deputy registrar.
No, my lord, it's an, yes, order, impugned order is by the deputy registrar,
Will
but your lordship may
matter
kindly.
also along with
No,
this
no,
the earlier
This matter was listed, my lord. It has been heard on his request. It was urgent today, my lords.
Yes. My lord, on the last date of occasion, I had undertaken that I'll argue today. Last date, I had received a copy, my lord. I had also engaged senior counsel, but he's not available. That's why I'll argue if my lord tells me.
Your lordship may kindly
On the
see page
maintainability, my
26,
lord.
my lord. Earlier, matter had come before the High Court, my lord, page 26.
Yes.
Some persons had come to High Court claiming that they are eligible voters, but their names have been wrongly included as ineligible. They were permitted to vote and their votes were kept separately. Ultimately, writ petition was disposed of. The operative portion is para 3. In the light, the writ petitions are disposed, calling upon the respondent returning officer to announce the result forthwith, including the votes cast by the petitioners.
Yes.
Then that matter was taken up in writ appeal, saying their votes should not be included and it should not be counted. Page 29, my lord.
Yes, I have seen the division bench order.
Order also. Pursuant to that, result is announced. One of the candidate files a writ petition, I mean section 70 dispute, saying permitting these persons to vote, etc. is wrong. All those things he makes the allegation. And in that petition, office bearer selection is stayed. So there will be no committee formed. there will be an administrator for the society. Office bearer selection in an individual election petition, if it is to be stayed.
What do you say?
Yes, Lord.
Already I have, last week I have submitted, your lordship, as he has filed a petition, application saying that there are some malified intention, and your lordship, they have stated, they have permitted to cast the vote, but wherein some of the members were deceased, your lordship. They have also casted vote, dead persons were casted the vote. So prima facie, when I found that there is some mischief is going on, that is the reason I have granted the stay, your lordship.
No, how
It is
the affairs of
submission,
the-
your lordship. It is
How
the-
the affairs of society will go on now?
Please, your lordship.
How the affairs of the society will go on? Who will take care of it?
Because administrator will.
Is appointed.
This,
No, he is not appointed, Murad. Now the elections to be held for the post of office bearers. At that stage, they filed the election petition, and now the DRCS has stayed that process. In fact, none of the persons who are stated to be dead, they have not voted. An endorsement is issued by the returning officer saying that out of the 9 persons, none of them have
application
voted.
made by the petitioner.
No, it is not that. If there is a,
I
there
have
is
made
a
an
challenge.
application, my lord. I will point out on that, my lord. Kindly, my lord, I will first argue on the basis of the whether this petition is maintainable or not before this honorable court on two limbs, my lord. Kindly see, the DRCS, jurisdictional DRCS has granted an interim order. Now, what they have done is they have not even filed vacating stay application there. They have directly approached this honorable court. This is the first thing. Second thing is whether writ petition is maintainable on the order passed under 71(3) of the Karnataka Cooperative Societies Act, my lord. Kindly come to page number 47. Admittedly, application is made under order 71(3). My lord, right from the year 1977, 1988, this honorable court time and again held that any order passed on interim application has to be challenged in 107 of the Karnataka Cooperative Societies Act. If my lord takes 107, it is clearly written. That number one. Number two is, my lord, now I have demonstrated before the DRCS that dead persons have voted. Now that is the reason the DRCS has granted interim order. Now what they should have done is they should have filed an vacating stay application before the DRCS, and they should have prayed they should have prayed for vacating the stay.
What is the other matter where AG's appearing is posted?
13th.
AG, huh?
13th.
This is matter also on 13.
13th. Seal number 51.
Serial number 51, I request for 2 weeks time, notes to compliance and my notes, I'm seeking dispensation of notice for respondent number 2 to 5.
The petition shall comply with the office objections within a week,
Please.
or else the risk petition shall stand dismissed and shall furnish, also
Notes.
shall the PF
Notes, I'm,
for issuance of notice to,
notes one submission. I'm filing a memo for dispensation of notice to 2 to 5.
a memo is filed seeking dispensation of notice to
2 to 5.
2 to 5. He shall pay the process for
Arun has already paid notes.
Huh?
For respondent number 1, I had already paid.
already paid, yes. Yes, next 52.
Seal number 52. Subhash Badvi.
Which time may be cut? Which time may be cut? We'll come.
Questioning the maintainability of the petition.
The identical cases, my lord, this is the case where, my lord, we have challenged the limitation, GMAC, where the 7 to 11 application is filed, along with the 166 clause 3. 166 clause 3, the special provision available to the insurance company where we have challenged the limitation. So under that provision, we have filed the writ petition. And in several cases, my lord, office objection have been overruled. And this is the first time we have received the objection. We'll
Submitted that in similar matters, the office objections are over. The petition shall comply with the office objections within 2 weeks.
please.
Yes, next.
Which time?
54.
Number 54. Sorry, 53. Sharanappa Swangadi.
Please.
Amit.
I for dispensation, my lord, certified copy. I for dispensation, my lords. May be allowed.
I1 is filed. Seeking dispensation of the, why it should be dispensed with?
The certified copy is produced in the connected matters.
To dispense with CC, certified copy of the judgment, as in the connected matters, they have filed the same.
Delay may be condoned with 53 days delay.
Huh?
53 days delay, I for condonation of delay. 53.
Later.
My lord,
Yes.
in this case, my lord, I am filed a withdrawal of the amount, my
Where
lord.
is that?
Uh,
I number 2 of 20.
I am number
Seeking to withdrawal of the deposited amount.
4, my lord. I am number 4.
What is this proposed like? I remember this case.
I'm
First of
the-
all, they have to be shown as the LR application has to be allowed. Without that, we will not propose to parties. How will they withdraw the money?
My lord,
As I said on the last occasion. Yes, next, 54.
Same my lords, of
Yes.
same LAC
my lord,
matters.
any date may be fixed, my lord, in both matters, my lord.
List both the matters list on 18th of February.
18th,
Yes, 55.
Please.
Please.
seal number 55. Srinivas Vinayak.
In this matter, your lordship, this is
The petition has
judgment, your
become
lordship.
infractious, my lords. Infractious ಆಗಿದೆ, my lords, petition.
Take that. There is a memo.
Because they have to raise dispute before the, under section 70, your lordship. They have to approach the, under section 70, your lordship.
No, they wanted, they say it is infractious. Whatever they want to do, let them do.
Because there was an order, your lordship, not to precipitate, your lordship.
No, that order will go. That order will go. What is a memo? Where is the memo?
I'll write down.
A memo is filed stating that the petition has become infractious. The memo is taken on record and dismissed as infractious. It's 56.
Seal number 56, memo is closed.
I filed recalling application, my lords. The matter was dismissed for non-compliance.
Why should we condone the delay of these many days?
We were not aware that the order was peremptory, my lords. We were not aware that the order was peremptory, my lords. This,
Not aware, we can't help it. You have to be
It was-
aware when an order is passed.
these matters, the matter was for the first time non-compliance, my lords.
IA 1 of 26 is filed to condone the delay of 310 days in 8 days in filing the recalling application. The reason stated, the delay is condoned and I order dated 5/2/2025 is recalled. The issue notice the respondent. Yes, 57.
57. Harish Maigur.
It is a case of death, means only income and multiplier has to be changed. That is the question. This is the fourth time, my lords. He is the only son. And income taken is 3,750, ought to have taken 5,000.
Where is the other side?
And my lords, contesting respondent is served and unrepresented. And insurance is admitted.
United India Insurance.
In serial number 57, madam.
Yes.
57, I undertake to appear for the insurance company. Kindly, 2 days accommodation, by that time I will collect the records.
Swiyaji.
He has instructions to file wakalat on behalf of R2. This is matter on Tuesday. Yes.
Much obliged.
Yes.
Also on Tuesday.
58.1, my lord.
Serial number
My lord,
58,
become
my lord.
infracture.
I am for the contesting respondent and I will move the matter.
58.1. 10801. It has become infractious, my lord. The tender work period itself is over.
Yes, that is why I moved the memo.
Filing.
While moving the memo, I have submitted that, my lord, the petition has become infractious.
Terminated.
Tender.
Lord, may I make one submission?
Yes.
Lord, I appear for respond number 4, and this was a tender matter. Lord, I had taken this matter to the appellate authority, and the appellate authority cancelled the tender. By virtue of an interim order granted by this court, Lord, the tender has been operated for the full period of 5 years. And your lordship may restore the appellate authority's order. Not simply dispose of the matter as having become infractious, Lord, that will entitle the petitioner before your lordships who has played fraud on the tendering authority as well as before this honorable court to again participate in the fresh tender if any called for.
Now, may I make a submission, my lord?
Annexures are.
February.
In this matter, my lord, the period of contract is over.
It's 59.
59.
Lordship, appeal by insurance company, Lordship, challenging quantum of compensation, Lordship. Tribunal has awarded sum of rupees 59 lakhs, Lordship.
59 lakhs.
Please, Lordship, 59 lakhs 82,000, Lordship. Out of which, Lordship, 5 lakhs has been paid by the owner towards the medical expenses, Lordship. That ought to be have deducted, Lordship. That has not been done, Lordship. Only 5 lakh is in dispute, Lordship.
So then deposit 54
Please, Lordship.
and they let them withdraw. It's a case of death.
Case of death, Lordship.
It is submitted that 5 lakhs medical expenses filed with employer was not deducted, and the insurance company is only on that ground before this court. Considering them, there shall be stay of all further proceedings on the condition that the petitioner, the appellant shall deposit 54 lakhs within 4 weeks, and on such deposit, the respondents are at liberty to withdraw as per the conditions laid down in the award. Notice to the respondent.
Much obliged, Lordship.
Yes.
Seal number 60. Issue signed, partly.
NHI matter, man.
Hmm?
NHI matter. The division bench has granted stay in the similar matters, and this court has also granted stay.
Take
May I
that.
pass on?
Take that.
There is 13 days delay in filing the appeal, my lord. The Shokas arrest warrant has been issued against the project director. So we are ready to deposit the entire amount. Some time may kindly be granted.
It is submitted that in the connected matters, the division bench of this court has passed an order in writ appeal number.
Please.
What is this order? MFA number
MFN.
106359 of 2024.
Please.
Hence, in the light of the same, this court is passing the following order. Look at it. We have, earlier also some orders are passed.
My lord, I may premature take notice to respond number 1.
The order. The notice to the respondent.
1 and respond number 2 government.
Respondent number 2.
No, government.
Who takes notice?
Government, deputy commissioner, state government.
SCGP.
For respond number 1.
2. And respond number
SCGP
3.
takes notice for respondent number 2.
Respond number 3, Rakesh Belgi may be permitted.
Respondent number 3, so and so is directed to take notice.
Rakesh Belgi, NHI. Please.
Then 1.
Please.
1.
R1 notice has to.
Notice to R1. Petition is permitted to take out hand summons.
Please.
Yes, 61.
Yes.
61. Seal number 61.
The appellant hearing challenge the I number 4 matters which is passed by the trial court rejecting the application.
What is this IA number?
This I number 1, my lords, I filed 151 application. Kindly she must dated.
No, what is this IA before this court to implement
This-
the proposed R2?
But my lord, while I am drafting this read petition, I have left out this gentleman. That is the reason I will file.
Number 1 of 2026, it is submitted that respondent number 2 is a party before the trial court. However, in the causeless,
In IA, he is made as a party. His application.
IA is
Yes,
made
ma'am.
as a party, but however, in the writ petition is not impleted by the petitioner. Hence, he has filed IA number 1 of 2026 to implement him as R2. IA is allowed. Petition shall file the amended copy.
Yes, ma'am.
Seal number 62. Tejeshwar K. 62.
Appearing for the petitioner's minutes. Minutes, I number 1 is for amendment of plaint minutes, because minutes, after filing of this writ petition minutes subsequently, minutes attachment warrant has been issued against the petitioner's minutes. Minutes, kindly see the page number 9 of the IA minutes. Despite being filing the objections minutes, in the next date they have taken the objections has been not filed, and attachment warrant has been issued against the petitioner's minutes.
To argue 62.
Yes,
There
madam.
are 3 matters. Where is the order in 62?
Minutes, in the 62 minutes, kindly see the page number 9 minutes in the IA minutes, annexure C minutes.
Please come to the impugned order.
Yes, minutes. Minutes, initially I have challenged the impugned order, annexure B and,
I will not hear anything. Please come to the impugned order. Let me read the impugned order.
yes, minutes.
Yes.
Minutes in page number 9 minutes, IA annexure C I have marked minutes.
First writ petition is 1000511.
Yes, my lords. My lords, in that subsequently I have filed the IA1, my lords. In that I have filed the annexure C, my lords. The impute order itself, that itself, my lords. Kindly see page number line, my lords.
In the writ petition, you are not filed the.
No, my lords, I have challenged in the writ petition, I have challenged the execution petition, my lords. In it subsequently they have issued the arrest warrant, my lords. So I am seeking that, my lords. Kindly please see, my lords, page number 9 of IA, my lords.
Where is the order?
My lords, in page number 9 of the IA, my lords. Annexure C, my lords.
You should file a separate writ petition for that. How will you seek the amendment? There are already you have questioned one order.
No, my
This
lords.
is the subsequent order.
No, in that execution petition itself, my lords, I am questioning only one order dated, my lords. I have filed the objections, my lords. They have taken as not filed, my lords. Kindly see page number 9, my lords. Objections of JDR number 2 is filed. Advocate for JDR number 2 praise time. For objection of JDR number 1 by 21/2026, my lords. Subsequently, in the next date, my lords, 21/1/2026, my lords. Advocate for JDR number 1 praise time. JDR number 2 and JDR number 2 are called out, absent, no representation is made. Sufficient time is given to JDR number 1 and 2 to file objection. No valid grounds for further adjournments. Prayer is rejected, hence objections of JDR number 1 and 2 is taken as not filed, my lords. My lords, at the request of the advocate for DHR, issue attachment warrant against JDR number 1 and 2 if PF is paid and LC charges are deposited within 4 days from today, failing which EP stands dismissed without any formal order to effect. DHR is directed to follow the bailiff. If the DHR fails to follow the bailiff, it is needless to state that EP will be dismissed. Avoid process, my lords.
When was the EP filed?
My lords, EP was filed on. My lords, just a minute. EP was filed on 24/10/2024, my lords.
What were you doing? When were the notices served on you?
No, my lords, I have regularly appeared before the court, my lords.
Where are your objections then?
Ma'am, kindly see the order sheet, my lords. They itself say that, my lords, I have filed the order sheet. I have filed the objections, my lords. In subsequent orders, they say that, my lords, I did not file the objections, my lords, and the attachment warrant has been issued. Kindly see the last paragraph of page number 9, my lords.
Page number 9 of what?
IA, my lords.
Yes.
Yes, my lords. In that, my lords, kindly see, my lords, in the first date, my lords, that is 13/1/2026, my lords, they say objections of JDR number 2 is filed, my lords. Advocate for JDR number 2 praise time for objection of JDR number 1 by 21/1/2026, my lords. In the next date, my lords, subsequently advocate for JDR number 1 praise time. JDR number 2 and advocate for JDR number 2 are called out, absent, no representation is made. Sufficient time is given to JDR number 1 and 2 to file objections, my lords. My lords, already I have filed the objections, my lords.
number, please come, my number 1 of 26 is filed the amendment. Thereby, the petitioner seeks another prayer to quash the attachment warrant of movables issued against the petitioner number 1 and 2 dated 21/1/2026. The IA is ordered and the petitioner shall carry out the necessary amendment to the cost item. Where is the first order? What is the first order?
My lord, first order itself filing of the execution petition, my lords.
Where is the first order you have?
Yes, my lords, kindly, my lords. Page number 19, my lords.
Is not the order.
No, my lords, execution petition is the page number 19, my lords. Annexure B1 is, my lords, at page number 29, my lords. Order sheet starts from page number 24, my lords.
What is the order we passed in this?
No, my lords, subsequently notice was issued, my lords, in the initial stage, my lords. They have appeared and they have filed the wakalat, my lords. In the next date, they will file the objections, my lords, on behalf of the JDRs, my lords. After filing of the objections, they said that you did not file the objections.
I don't want all this essay.
Yes,
I just said What is the order, first order that is passed? You have filed the writ petition,
Yes,
isn't it?
yes, my lords.
What is the order you have questioned?
I have questioned the challenge the,
Show me that operative portion of the order, page number.
yes. Let's, in first I have challenged the filing of the execution petition itself, my lords.
Can you question it?
No, my lords, no, sir.
Writ petition?
No, my lords.
No, the main prayer itself is not maintainable. Now you seek an amendment prayer in this.
No, my lords. In the last date of hearing, your lordship has directed to carry out necessary amendment, my lords. So I have made this amendment, my lords.
I number 1 is filed, questioning finding of the execution for the proceedings. And this court has permitted the petitioner to file an amendment to question the order where the attachment order is passed. Now by virtue of this IA, petitioner has filed the amended prayer. The amended, accordingly, IA is allowed. Next, it is submitted that the court had passed the order and issued the arrest warrant against the JDR 1 and 2. Petitioner is JDR number 2.
No, a petitioner is JDR number 1 and 2, my lords. Petitioner 1 is the son, my lords. Petitioner 2 is the father, my lords.
But only 1 is filed. JDR number 2 has filed, 1 has not filed.
1 is not filed, my lords. He 6 times, my lords, to file, my lords.
Your submission is
Yes,
JDR 2 has filed.
yes, my lords.
But JDR 2 we will stay.
Yes, my lords. Yes, please, my lords.
The JDR is appearing for JDR 2 and 1. As far as JDR 2 is concerned, he has already filed his objection. The court, without considering the same, has held that both JDR 1 and 2 have not filed. Considering the submission, as far as JDR number 2 is concerned, there shall be stay of all further proceedings.
Minutes in the meantime, 1 also minutes because minutes I'll file in the next date itself, minutes, because there are, yes, ma'am, liberty may be given to file the objections of the JDR number 1, minutes. Kindly please, minutes.
Notice to respondents. Both, don't
Yes.
say it, it's only JDR for number 2. They say there shall be stay of all further.
Yes, minutes.
Other
Admission
petitions.
Copy may be permitted to serve on trial court advocate, minutes.
What is the 62.1 and 62.2?
Same minutes. Petitioners are the same minutes, but the different execution numbers, that's all, minutes. Only the execution petition numbers are the difference, minutes. Petitioners and the respondents are same, minutes.
Same one. But I is also same. Yes.
Admission, madam?
My lords, one submission, my lords, with your permission. Serial number 55, it was a mistake, my lords. It was not infructuous, my lords, the petition.
Why did you say?
No, my lords. In respect of other society, it was infructuous, but there has been some mistakes. There have been some miscommunications.
As I have submitted, your lordship, they have to approach under section 70, your lordship. As disputed facts are there, your lordship. They have, her applications were rejected, the nomination was
Nomination
rejected.
papers of the petitioners were rejected, my
No
lords.
interim order in this.
Interim orders were there, your lordship. For that reason, similar writ petitions were disposed of.
55 list after tomorrow.
Please.
My lords, on Monday, my lords, I request on Monday.
I will confirm that order if you ask for anything. Yes. Unnecessarily you waste court's time.
Sorry, your
Without
lordship.
even verifying the papers.
I'm
Yes,
sorry,
next.
sorry, your lordships.
Admission, madam, serial number 63.
In this case,
Please, Lord.
may I made one
Filed-
submission, my lord.
I for return of LCR, lordship.
One submission, my lord. In this case, my lord, we are not panel on the Kotak Mahindra, my lord. By oversight, my name is shown, my lord. Kindly delete my name, my lord, and notice me kindly be issued.
Read the name of Mr.
Nagaraj C. Kolluri.
Menso, which is the respondent.
Yeah.
Respond number 2.
Respond number 2, my lord. Respond number 2, my lord.
So Mahindra Bank. What is the bank doing in this MBA? What is why the bank is a respondent?
Lordship.
Insurance company, my lord.
Insurance
Kotak
company,
Mahindra
Lord. Kotak
General
Mahindra
Insurance
General
Company, my
Insurance
lord.
Company, Lord.
It's an insurance
Who
company.
is other counsel appear? You have no clue?
No, my lord.
Yes, no notice to the first respondent. Issue notice to second respondent.
Please, ma'am.
Please, Lord.
Yes, 64.
Lordship, meanwhile, Lordship, LCR may be returned to the trial court for enabling the withdrawal of the amount in deposit, Lordship.
I number 1 of 26 is filed, but you know, the PCR to enable the petition to, what is that to take that amount?
Please, Lordship.
To enable the petitioner to withdraw the amount. LCR, Registry is directed to send the PCR. Once the amount is withdrawn, the same shall be sent back. Yes, 64.
Please.
Seal number 64.
Appearing for the petitioner, my lord. My lord, it's a petition for appointment of a sole arbitrator. A notice may be issued on the respondent, my lord.
Issue notice. Seal number 65.
My lord, I am for the appellant and stay was only for 4 weeks from January. Therefore, it may be kindly be extended, my lord.
The amount is deposited.
Amount is deposited, my lord.
Then counsel for the insurance company submits that as per the order passed by this court, they have deposited the amount. Hence, there shall be stay of further proceeding until further orders. Admit also final hearing, call for the TCR. 66.
Same. It is also
66.
connected, my lord.
Yes. 67.
67. Munir Ahmad, Saudakar, MK Saudakar. MK Saudakar.
What is like, it's not working today, it's not at all clear. Yes, this matter tomorrow. Counsel is on the court is due to technical glitch. Court is not able to hear the counsel for the appellant. This is a matter tomorrow. Yes, 68.
68. DLR Khan.
Defend number 3 is before this court against an order of injunction not to alienate the suit property. Plaintiff's case is that they have filed a suit for partition and separate possession as well as declaration. Claim of the plaintiff is that they were minors at the as on the date of the registration of a sale deed. Sale deed of defend number 3 he refers to 21/10/2021. Now the suit is been filed in the year 2025, my lord. Since 4 long years, there was no impediment and restriction on the defendant to enjoy the property. Now, by virtue of this partition suit, now the plaintiff wants to see that defendant number 3 does not enjoy his property in entirety. The trial court, while considering the IA number 1, refers to at page number 24 at last 8 line from the bottom. It is pertinent to note that the defendant number 3 has not at all stated that he is not trying to transfer the or alienate the or create third party interest over the suit schedule. The case of the plaintiff is that the Karta has executed a sale deed. Even the
It's only stay of alienation. If it is not, the whole purpose of it will be.
no, my submission is that the entire property, two properties are involved in the suit property. One is agricultural land. If at all they have got any right over this property, they can forfeit and adjust with the first property. It is not the case that it is the case of the defendant that he has purchased the property from the defendant number 2 by virtue of a registered gift deed. One.
According to the plaintiff, it's a joint family property. They were minors at the time when the sale.
No. If minority is to be considered, my lord, may I take your lordship to page number 1 of the plaintiff itself?
Of the matter.
No. My question is.
The suit is barred by limitation. If that is your case, you can.
No. That I have already filed a written statement. I also have filed an objections to the very application maintainability of 39(1) and 2. That is, the first basic question is that there are no pleadings with respect to the legal necessity or necessity for the person to sell the property. Lame excuse that this is nothing but a sham suit filed by the very defendant number 1 father through the children. That is not permissible under law.
Notice to the respondent.
Let this order be stayed, my lord.
Notice to the respondent. Petition is permitted to take out hand summons.
May I request a date making?
Seal number 69.
File a memo to that effect. This is marked on 24.
Please.
Remaining matters, give a date as per their convenience. Yes. Any this thing for signature.
Last one. Online scam suffered by the petitioner.
That matter listed as a first matter tomorrow.
Serial number 69.
Yes.
May I kindly have it tomorrow or day after tomorrow also. Please.
Court officer. Court officer.
Court officer. Interim order is to be extended. Mention ಮಾಡೋದಿತ್ತು.
Court officer.
Yes. 69 Santosh Bhimane.
Day after tomorrow. Day after tomorrow.
Sir, 9th. Sir, 9th. Monday. Tuesday. 10. 70 Santosh. Sir, ನಾಳೆ MF ಮೆಟ್ರ್ ಇರ್ತಾವ. ನಾಡಿದ್ದು ಸರ್ 6. 71
ನಾಳೆ.
MF ಮೆಟ್ರ್ ನಾಳೆ MF ಮೆಟ್ರ್ MF ನಾಳೆ 6. 72 Deepak. Hi sir, 10. 73 Lakshman T Mantagan. ಯಾರಿಲ್ಲ ಅರ್ಜನ್. 74
ನಾಳೆ ಸರ್. ನಾಳೆ ಸರ್ ಸಿರಾಜುದ್ದೀನ್.
ನಾಳೆ ಇಲ್ಲ ನಾಡಿದ್ದು ಕೊಡ್ತೀನಿ 6th.
ಓಕೆ ಸರ್. ಓಕೆ ಸರ್. ಓಕೆ ಸರ್.
75 ಯಾವ್ದ್ರಲ್ಲಿ 75 ಹಾ 75 entry mod actions date ಇಲ್ಲಲ್ಲ list after 2 weeks. 76 ಶರಣ ಬಸವ ಇಲ್ಲ ಶರಣ ಬಸವ ಕೊಂಡು ಮೇಡಮ್ ನಾವು ನೋಡ್ಬೇಕು. ಸೆಕ್ಷನ್ 77 ಸಂಗ್ರಾಮ್ ಸರ್ 17 ಸರ್ 16 yes 16 78
10th ಅದು ಹಿಯರಿಂಗ್ ಆನ್ ಐ ಫಾರ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿವಿ ಮೇಲ್ ಬರ್ಬೇಕಾಯ್ತು.
vacating 76 ಸರ್ ಅರ್ಜೆಂಟ್ ಸರ್ ಸರಿ ಸರ್ ಲಿಸ್ಟ್ 2 ತಗೋಲ್ಲ ಲಿಸ್ಟ್ 2 ಅಭಿನಂದನ್ ಅಭಿನಂದನ್ ಬಂದ್ ಜಗಳ ಮಾಡ್ತಾನೆ
ಸರ್ 11 ಸಾಹೇಬ್ರೆ ಅಲ್ಲ ಸೀ ನಂಬರ್ 1 11
ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ
11 ಸೀ ನಂಬರ್ 1 11
ಲಿಸ್ಟ್ 1 ಸರ್
79 ಏನಂತ ಒನ್ ಲಿಸ್ಟ್ ಗುರುವಾರ
11 ಸರ್ 23 ಸರ್ ಸ್ಟೇಟ್ 23 ಇಶ್ಯೂ ನೋಟಿಸ್
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
ಇಲ್ಲ ಮೇಡಮ್ ಇದ್ದಾಗ ಆಗಿದೆ ಆರ್ಡರ್
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಅದು 10th ಅಥವಾ 11
ಯಾವ್ದ್ರಿ
10 ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇನ್ ಸೆಕೆಂಡ್
ಲಿಸ್ಟ್ 1 10th ರೀ
10 ಸರ್ ಲಿಸ್ಟ್ 1 79
ಸರ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 3
ಹ್ಞೂನ್ರಿ
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ರಿ.
ಎಂಟ್ರಿ ಆರ್ಡರ್ ಐತ್ರಿ
ಹಾ
ಲಿಸ್ಟ್ 1 79
4
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಆಯಿತು ಸರ್. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 3
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಸರ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 10th ಸರ್
11
ನೆಕ್ಸ್ಟ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹಾಕ್ತೀನಿ ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕ್ತೀನಿ ಸರ್ ನಾನು ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಇದೆಲ್ಲ ಹಂಗೆ ಕೊಡ್ತಾವೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟಿಗೆ ಬರ್ತೀವಿ ರೀಚ್ ಆಗೋದಿಲ್ಲ ಮತ್ತೆ ಮತ್ತೆ ಸ್ವಲ್ಪ ನೀವು ಹೇಳಿದ್ರೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ
ಸರ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಒಂದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ರಿ ಅದರಲ್ಲಿ ಪ್ಲೀಸ್.
10th
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 5
ಸೀರಿಯಲ್ ನಂಬರ್ 5 KH ಪಾಟೀಲ್ ಎಂಟ್ರಿ ಮಾಡರ್ ಟೆನ್ಷನ್ ಎಂಟ್ರಿ
Sir, first list. 10th. Sir, first list ನಾಗ 79.
ಇದು ಮುಗಿಸ್ತದೆ. ಒಂದನೇ. ಮುಗೀತು. Till number 6.
ಮೇಡಮ್
11.
ಹಾ ಸಿರಿ
11 ಐತಲ್ಲ?
ಆಯ್ತು
10th.
11 2 ಲಾ
ಹ್ಞೂ 11 2 ನ ಕೊಟ್ರಿ 7
10 ಸರ್ 10
ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ
7 ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ರಿ
ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಹ್ಞೂ ಡೇಟ್
ಎನಿ ಡೇಟ್
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks
3 ಒಂದೈತಲ್ಲ ಅದೇ ಲಿಸ್ಟ್ ಒಳಗೆ
3 ಆಗಿದೆ ಸರ್
ಆಗಿದೆ
ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿದೆ
ಡೇಟ್ ಕೊಟ್ಟಿರಲ್ಲ
ಡೇಟ್ ಏನು ಹೇಳಿಲ್ಲ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks
ಸರಿ
8 3 ಅಂತ ಕೇಳಿದ್ರಲ್ಲ 2 weeks ಅಡ್ಜರ್ ಎಂಟ್ರಿ ಮಾಡಿರಲಿಲ್ಲ ಅಲ್ರಿ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲ
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್ 10th
ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ 79
ಸರ್
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ರು
79 ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಟುಮಾರೋ ಸರ್
ಟುಮಾರೋ ಓಕೆ
ಎಂಟ್ರಿ ಮಾಡೋ ಐತೇನು ಸರ್ ಅದರಲ್ಲಿ
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಿಲ್ಲ
ಕೊಟಕ್ ಮಹೇಂದ್ರ ಇಲ್ಲಿ ನೋಡಿದ್ರೊಳಗ ಅದನ್ನ ಯಾಕೆ ಸೇರಿಸಿಲ್ಲ ಅವರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಡಮ್ ಕೊಟಕ್ ಮಹೇಂದ್ರ ಒಂದು ಬರೀ ಮೇಡಮ್ ಬರೋದು ಯಾವ ಸೇರಿಸ್ರಿ ಸರ್ ಸ್ವಲ್ಪ ಅಪ್ಡೇಟ್ ಪ್ಲೀಸ್ ಅಪ್ಡೇಟ್ ದ ಲಿಸ್ಟ್ ಪ್ಲೀಸ್
disposal of alert preliminary hearing and time to
ವಿರಾಟ್ ಸಾಗರ ತೊಗೊಂಡ್ರಿ ಮೇಡಮ್ ಬ್ಯಾಸ್ ಚಾಲು ಆತನ್ರಿ ಥಂಡಿ ಅಲ್ಲ
ಬ್ಯಾಸ್ಗೆ ಇದಕ್ಕೆ ಶುರು ಆಗುತ್ತೆ ಇದಕ್ಕೆ
ಸಮ್ಮರ್ ಕೊಡ್ರಿ ನೀವು ಡಿಸ್ಪೋಸಲ್ ಬರೀತೀನಿ ಎಷ್ಟಾದ್ರು ಹೇಳ್ರಿ ಡಿಸ್ಪೋಸಲ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಎಲ್ಲ ಆಗ್ತಾವ ಸರ್ ನೋಡಿ ಕಳಿಸಿ ಬಿಡ್ತಾರೆ
11th ಗೆ ಐತ್ಲಾ ಅದ್ರದಾಗ ಸೀನಿಯರ್ ಅಪ್ಲೈ ಆಗ್ತಾರ ಅದಕ್ಕೆ
ಎಲ್ಲ ಕಳಿಸಿ ಬಿಡುದ್ರಿ ನೆಕ್ಸ್ಟ್ ಇದ್ದಾರ ಹೌದು ಯಾರಿದ್ರಿ ಈಗ ಆರ್ಎಚ್ ಇದ್ರಲ್ಲ ಆರ್ಎಚ್ ಕಳಿಸ್ಬಿಡಿ
ಎಲ್ಲ ರೋಹನಿಗೆ ಇನಿಷಿಯಲ್ ಹಾಕೊಂಡು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನ ಹಾಕೊಂಡು ನಾವೆಲ್ಲ
ಓನ್ ಲಿಸ್ಟ್ ಹಾಕ್ರಿ ಎಂಟ್ರಿ ಮಾಡೋರ್ತಾವ
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಏನು ಮಾಡ್ತೀವಿ
ಇಲ್ಲ ಡೇಟ್ ಬರೋದು ಕಳಿಸಿ ಬಿಡುನ್ರಿ ಎಂಟ್ರಿ ಮಾಡೋದ್ರಿ ಎಲ್ಲ ಹೌದಲ್ಲ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂದ್ರಲ್ಲ ಅದೊಂದು 79 ಮೊದಲು ಕಳಿಸ್ಬೇಕು ಏನ್ರವ ಸುಮ್ಮನೆ ನಾ ವಿಡ್ರಾ ಮಾಡ್ತೇನ್ರಿ ಅಂತ ಹೇಳಿ ಇಟ್ಕೊಂಡು
ಅವ್ರ ಆರ್ಡರ್ ಕಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ
ಮೇಡಮ್ ಇದು ಫ್ಲಾಗ್ ಹಚ್ಚಿಡ್ಲಿಕ್ಕೆ ಇಲ್ಲೇ ಇಟ್ಬಿಡ್ತೀವಿ ಕಳಿಸ್ಬಿಡ್ತೀವಿ ಹಿಂಗೆ ಕೆಲಸ ಗಂಗಾಧರ ನನಗೆ ಬಿಡೋದು ಬಿಡ್ತಾ ಇಲ್ಲ ಮೇಡಮ್